weekly list. Weekly list old matter item number 1.
None appears dismissal not possible.
Poultry amount also.
Weekly list old matter item number 2.
None appears dismissal not possible.
Weekly item number 3.
None appears non dismissal not possible.
Weekly list item number 4.
Lordship, poultry amount.
Kindly withdraw.
All right. No, who?
Liberty to one share.
Item 4 in the weekly list, please. This is sales tax revision.
Your Lordship, it is poultry amount. Your Lordship, 12,500.
Amount is fallen. Insignificant and therefore question of law is left open. 5 also?
5.
5, your Lordship.
No, correct address not filed.
Minor.
Steps have not been taken to serve opposite party. This was not possible.
6,
Weekly
your
list item
Lordship,
6.
1,421. 1,420.
6 is poultry amount.
Your Lordship, 7, your Lordship, the amount is high, your Lordship. File is not available.
That's what. You say the file
Your
is not
Lordship,
traceable as and when the
Lordship,
file is traced. No, as and when the file is traced, an application can be filed for revival of the
Obliged, your Lordship.
petition is dismissed.
Weekly list item 8.
None appears dismissal not possible.
Weekly list item number 9.
Okay. None appears dismissal not possible.
Weekly list item number 10.
My lord, question of law has already been answered by the Apex Court.
All right.
No, your Lordship. Your Lordship may kindly turn to the tribunal's order.
No, where is the judgment of the Supreme Court? We have the judgment of the Supreme Court.
No, my lord.
How do you simply make a statement then? No questions have been framed yet.
Okay.
Even questions have not been framed yet.
Not.
What is the tax amount?
2 lakh.
Tax amount is 2,51,000.
Ah.
But your Lordship, it has been set aside it to the assessing officer to make fresh assessment portion as per the judgment of Honorable Supreme Court in Gannon Donker case.
So that must have already been
Your
done.
Lordship, your Lordship.
There
Your
has been
Lordship,
no
may kindly-
stay order passed in the present revision petition. The impugned order of the tribunal only remands the matter to the assessing sales tax officer to make an assessment afresh following the judgment of the Supreme Court of India in
19
Gannon Dunkerley.
1993, 88 STC 2,204.
1993 88 STC
204.
204. That you have the matter, no substantial question of law arises. The petition is disposed of.
Obliged.
Weekly list item 11.
None appears dismissal not possible.
Weekly list item number 12.
Okay. None appears dismissal not possible.
Weekly list item number 13.
None appears dismissal not possible.
Weekly list item number 14.
None appears dismissal not possible.
Weekly list item number 15.
My lord, this may be passed over Mr. Misra, S.
All
P.
right.
Misra, senior advocate will address your lordship.
What is this item 15? What is which is
15, my lord, relating the challenging the order of the Tahsildar Banki, recording the name of the Lord Jagannath in the disputed property where the
All right.
petitioner said.
all right? Pass over.
Weekly list item number 16.
I may be permitted, my lord. Item number 12, sorry, just I missed out.
You just have to speak in the mic, sir.
My lord, item number 12, I was up.
Tell us what it is.
My lord, it's for OSFC, I am appearing, my lord.
Dismissal non possible.
My much obliged.
Weekly list item 16.
None appears dismissal non possible.
Weekly list item number 17.
None appears dismissal non possible.
Weekly list item 18.
No inspection, my lord.
Infructuous. All right.
Weekly list item number 19.
Item number 19 kindly pass over.
All right.
Weekly list item number 20.
None appears dismissed from opposition.
Weekly list item number 21.
None appears dismissed from opposition.
Weekly list item number 22.
None appears dismissed from opposition.
Weekly list item number 23.
23, my lord, kindly pass over, my lord. On behalf of Mr. Palit, kindly pass over, my lord.
So just remove your mask. Just kindly remove your mask. Ha, what are you saying, sir?
Kindly pass over, my lord.
Which item?
23, my lord.
23. All right.
Weekly list item 24.
Item 24 may be passed over, Your Lordship.
All right.
Weekly list item 25.
None appears dismissed from opposition.
Weekly list item number 26.
None appears dismissed from opposition.
Weekly list item number 27.
None appears dismissed from opposition.
Weekly list item number 28.
28, my lord, kindly pass over.
All right.
Weekly list item number 29.
My lord, withdrawn with liberty to file a.
Speak in the mic, sir. Speak in the mic.
Withdrawn with liberty to file a fresh and some developments are 29, 30, 31. 3 items are there.
Counsel, the petitioner states there are some fresh developments. He seeks leave to withdraw these petitions, with liberty to file a fresh petition. This is withdrawn with liberty.
Weekly list item number 32.
None appears dismissed from opposition.
My lord, pardon to make a mention, my lord. Pardon.
Not at this stage, please. No mentioning here.
Item number 12 and 30.
It's all gone. When we come back to it, we'll mention.
Weekly list item 33. Item 33.
None appears dismissed from opposition.
Weekly list item 34.
None appears dismissed from opposition.
Weekly list item number 35.
Same.
Weekly list item number 36.
None appears dismissed from opposition.
Weekly list item number 37.
A memo has been filed stating that an insolvency resolution professional has been appointed
37 your
in the
lordship.
proceedings concerning the petitioner before the NCLT, Mumbai bench. The counsel petitioner states that he has no instructions. The petition is disposed.
My lord, item 34, I am through BC, my lord.
All right, sir.
34 and 35, my lord.
All right, sir. Tell us.
May I please your lordships?
Yes, please.
In item number 34, my lord, the petitioner
Yes.
who was working as my lord, head clerk in the office of the CGM Balangir, at that point of time, he had filed a writ application challenging the gradation list. Now he has retired from service with effect from 31st Jan 2013, my lord. And only
Yes, please. What are you saying?
My lord, item 36 may be taken.
1 minute, sir. He's on 34 or so.
34, my lord.
Yes, yes. Carry on.
My lord, the petitioner at the time of filing of the writ application was working as head clerk in the office of the CGM Balangi. Now he has retired from service, my lord, with effect from 31st Jan 2013, my lord. In the present writ application, my lord, he has challenged the legality of the order number 23 dated 5/5/2011 passed by the Nagaland District Judge Balangir Sonpur, wherein the opposite party number 2 and 3 have been promoted to bench clerk grade 1 without being promoted and posted as bench clerk grade 2, though the post of bench clerk has become upgraded, my lord.
Yes, carry on.
My lord, your lordship, I kindly say the petitioner, my lord, originally joined in.
You're still interested in challenging somebody's promotion, although you're retired.
My lord, only for financial benefits because I
What
am
benefit will you get? If his promotion is cancelled, what benefit will you get?
my lord.
What? What does my lord mean? If his promotion is cancelled, what benefit do you get, sir?
Criteria is merit cum suitability.
Sorry?
Criteria is merit cum suitability.
I know. No, but assuming that man's promotion is cancelled, what benefit is he going to get? I think we'll pass it over. The network is moved.
34 and 35.
Yeah, pass over.
Item number. Item 36.
In the year 2011, my lord, that villagers filed a PIL before the Sonor court, praying for eviction of opposite part number 6, who has constructed a school on the Gochor land. On the Gochor land, my lord.
My lord,
3 times, my lord, 3
So we
times.
have passed it over. We'll take it up at the end of the board. All right.
my lord, after launch, I
It will come up before lunch, sir. Kindly make it
34 and
convenient to appear
35, my
before
lord.
us. Kindly make it convenient to appear before us.
Yes, my
Before
lord.
lunch, it will be called out again. Yes.
My lord, 3 times the Tahsildar initiated the encroachment proceeding in the year 1997, 98 you were evicted.
Yes.
Then in 2005 you were evicted.
Yes.
In 2008 another proceeding was initiated, he was evicted.
All right.
Again he has encroached that land in 2000. Till today he is encroaching that.
No, but there's already a school.
That is a private school, my lord.
That school is functioning now.
Functioning.
Why should we disturb that school, sir? Students,
That
everybody
on
gets affected.
Gochor land, report of RI is for 5 villages only, that is only Gochor land.
So there is no interim order. This matter has been pending for 11 years. The school is functioning for 11 years. Why should we disturb, sir?
My lord,
There are some things by passage of time we can't do anything, sir.
my lord, that is only Gochor land, only Gochor land of the village.
It's all right. You say the allegation is
My
that.
lord, I may pray, my lord, one thing, my lord. If any fresh cause of action arises, they may approach the Tahsildar, my lord.
All right. If you want to withdraw, then you withdraw. Counsel, the petitioner seeks leave to withdraw this petition with liberty to file a fresh, approach the Tahsildar if any fresh cause of action arises. Dismissed as withdrawn with liberty spread.
Yes.
All right.
Weekly list item 38.
Your Lordships, I'm appearing in this matter for the petitioner. I was supposed to file the wakalatnama, but it's.
That's all right. Tell us what it is.
Your Lordships, actually, we were all working as library assistant. And in the year, this is actually a claim of UGC scale, Your Lordships. In the year 1985, Your Lordships, we all, by annexure 1, page 14, Your Lordships, we all have been designated. May I just read this?
Yes.
After careful consideration, Governor has been pleased to decide that laboratory assistants in science subjects in non-government aided colleges possessing BSc qualification shall be designated as demonstrator bracket non-teaching and placed in the scale of 1090 to 150 with effect from the date this decision has been made applicable to the laboratory assistants in government colleges. Your Lordship, look at the last paragraph in that document. The above decision of the government is made applicable to the laboratory assistants of government aided colleges with effect on 1/1/1985. Your Lordships, we were laboratory assistants. We've been given the status of demonstrator from 1/1/1985, Your Lordships. Your Lordships, this document gets further modified under Annexure 2, page 15. Your Lordships, may I just hand over this date chart?
Yes.
Your Lordships, look at
So that non-teaching has been removed because
Yes,
you're
Your
also teaching.
Lordships.
All right.
And rightly so, because our post involves teaching.
All right.
Your Lordship, of course, there are two
Conditions.
conditions. I'll come to that. One of them is that the UGC scale of pay shall not be given to them at any point of time. May I just halt Your Lordship? These two documents are common throughout state of Orissa. This was a common document for all the universities, all the government and non-government colleges, by which Your Lordships, all these people who were working as laboratory assistant were given the status as demonstrator, and thereafter also understood that they have teaching. They count in the teaching faculties. Though while doing so, this UGC consideration was kept. This was one-sided arbitrary condition which was imposed on us. Having said so, Your Lordships, page 16, Annex 3, by which an amendment was given to the Odisha Higher Education Regulation 1982, thereby demonstrators either having an MSc qualification or demonstrators having a BSc qualification, both MSc and BSc are adequate qualification with 15-year experience, were also given the status of being examiners, which was after an amendment. That's Annexure 3, page 16. May I take to Annexure 5 also, which is a document of 2008. Annexure 5, page 52. Did Your Lordships get the document? Here, the government is writing to the Director of Higher Education with reference to letter cited above. I'm directed to say that the government, having been pleased to clarify demonstrator to be treated as teachers for their registration under CHEC because of the following reasons. One, because UGC in its report have placed demonstrators in teaching category, and the Honorable High Court in so and so judgment has also observed demonstrator teachers. I'll hand over that judgment. And also an apex court judgment in this regard. I shall give that to Your Lordships. Your Lordships, in this regard, Annexure 4 may be seen, which are guidelines of the UGC. Page 25 and 30. Page 25. Point number 5. The revised scale of pay of tutors and demonstrators is for the existing incumbents of these positions in the colleges and university and colleges. There shall be no fresh recruitment in this category, because they said that people thereafter will not, this was considered as a dying category. So there are limited people left in state of Orissa. And under page 30, the scale of pay is also given for the tutors and the revised scale of pay. That being so, I have also filed an affidavit today. May I just take Your Lordships to page 14 of that affidavit. Point 15. The heading is Scale of Pay of Teachers and Other Academic Staff in University and Colleges. Point 15, Demonstrators and Tutors. There's another revision of pay in 1998. So they're still being considered. That being so.
No, the college where you are all working is still a non-aided college.
Non-aided private colleges, but this UGC scale has been made applicable to all the staffing patterns except for demonstrators.
No, but who has to pay you? Because all your respondents are state bodies.
State bodies.
Why should they pay you? I mean, you're a non-aided college.
I shall come here. Come to this. May I just take the quote to page 23 of my brief. Whenever the UGC has to be implemented, the way it has to be implemented is given in page 23.
Yes.
Point 4. The scheme is being implemented in the central universities and other institutions fully financed by the central government. The government of India has decided to assist the state and government who wish to adopt and implement the scheme of revision of pay scale subject to the following terms and conditions.
No, but you are a private college, correct?
This aid would no the payment will be given to the given by the college, but the finance comes 20% from the government and 80% from the central government.
Why? I don't understand. You're a private college. Why would they?
Private, it's a private aided college.
I thought you said you were a non-aided college.
No, private aided college. It's Christ College in. Your Lordship, may I just show the people who are petitioners before you?
No, one is AB College, one is Anandpur College.
Christ College, then there is UN College.
No. We're talking of Samarendra Nayak, right? Petition number 1 is UN College. Petition number 2 is LN College.
This is applicable to the private colleges as well. That's there in the scheme itself.
Christ College. No, but why would the government pay these people if they're working in private colleges?
All the teaching patterns, they get grants, and all of them have been given the UGC scale. All the teachers, the readers, the lecturers, everybody in this college.
No. The question is who will implement and
the government. Once the sanction is given.
No, they are not even made parties. The colleges are not even parties. If they are not, where do you say that they are aided colleges?
They are aided colleges. May I just show Lordships page 23.
They are different non-government fully aided colleges.
Page 23, Lordships.
Yes.
The central government will provide assistance to the state government to the extent of 80% of the additional expenditure involved in giving effect to the revision of scale of pay. The central assistance to the extent indicated above will be available from January 1st, 1986 to 31st March, 1990. This is very important. The state government will meet remaining 20% of the expenditure from its own resources and will not pass the liability or any portion thereof to any university or the management of private colleges. The state government will take over entire responsibility maintaining the revised scale of pay. From April 1, 1990, the central assistance will be restricted to the revision of pay of the post which were in existence on January 1st, 1986. This scheme has been made applicable in state of Orissa. Only it is for the post of demonstrators. That also partially has been made applicable. Let me just demonstrate that. That being so, you will look at Annexure 11, page 54. The government has already taken a decision in this regard. Page 54. It's the government which is writing to UGC. May I just place that?
Yes, sir.
I'll just place point 1 that I think that from that it will. The laboratory assistants of colleges and universities of the state having BSc and BA qualification have been redesignated as demonstrators non-teaching with effect on 1/1/85 and the demonstrator with effect from 10/4/1989 in the state, and the scale of pay is revised from time to time. It is requested to kindly indicate as to whether UGC would be able to bear the burden of the area dues for the last 5 years in the event the state accepts a UGC scale for pay of demonstrators at a belated stage. Your Lordship, to which UGC gives its nod at page 55, Annexure 8. I am directed to refer to your letter number so-and-so, dated so-and-so on the above subject, and to inform that the central government will provide necessary assistance of a revision of pay scale of demonstrators subject to the terms and conditions laid on the Ministry HRD letter dated 17/6/1987, part of which I just read out, 14/7/1981 and 22/7/1988, which I just read out. This will be applicable to the existing incumbents only.
No. As far as central government is concerned, they will pay only till 1990. After 1990, entirely the state government has to bear the burden.
Let me just show that they actually there's already been orders of this court, and they have been confirmed in Supreme Court for payment of this. Only one part of some of the demonstrators are not getting it in state. Your Lordship, then look at Annexure 12, Annexure 13, page 66, Your Lordship. 64, Your Lordship, before that. UGC again reconfirms his position, which is at page 65. First portion of the last paragraph. I would like to reiterate that in case the state government wishes to revise the scale of pay of the demonstrator in state and central government would
It's the same
provide a
thing.
financial.
So only till 1990, the central government will bear it. So
Yes, Your Lordships.
So
Your Lordship,
not beyond that.
the decision is taken, Your Lordship, page 66. The government has already accepted in page 66. They took a decision. They asked all the institutions, university, government, non-government, to submit the name of the demonstrators. That has already taken place, Your Lordship. Page 66. 68, Your Lordship.
So what do they say in their counter affidavit?
Your Lordship, they say something which has been repeated and actually has been rejected by this court and approved in Supreme Court. That's what I wanted to show. Your Lordship, page 68.
So first, let us understand what they're trying to say.
Your Lordship, they say that the demonstrators will not be given because they're not teaching faculties. Your Lordship, to that extent, Your Lordship, there are judgments of this. Your Lordship, I've given. Your Lordship, the first judgment is of the year 1993, Your Lordship. This is Gitanjali Mishra versus State of Orissa, where this first time this question came up, whether demonstrators are people belonging to teaching facilities, teaching faculty. Your Lordship, may I take para 4?
No, but I think there was already a clarificatory circular saying the NT will be removed from the bracket 1989.
Yes, Your Lordship. From 1985, now we are held to be teaching.
Correct.
Does the stand? No, even in this case, Your Lordship.
That's obviously there. I mean, that's
yes, all this document. In fact, Your Lordships, what happened in midway, all those documents which are right now just placed, Utkal University implemented it. And the government said that you did not take our confirmation, you implemented it, withdraw it. That's how the petition, the demonstrators of Utkal University came up before Your Lordships. And in the judgment dated 39/19/2011, Your Lordships, which is the third judgment.
General Secretary Utkal University demonstrators.
Yes, Your Lordships. In that judgment, finally, the same documents, all the documents that I have placed, and particularly, Your Lordship, look at para 9, Your Lordships, where the government stand is there in that judgment.
Yes.
Opposite number 5, Your Lordship, opposite number 5 is state. It's then the cause title of the judgment. Has filed an affidavit 17/12/2009 as per the order passed by the court on 10/12/2000 regarding the scale of pay of the demonstrators working in universities, government colleges and non-government aided colleges. It was submitted that the demonstrators working under the universities, government college, non-government aided college are drawing the same scale of pay. It is further submitted the scale of pay availed by the demonstrators and corresponding scale in 85, 89, 90 and pay division rules where so and so and so. It is therefore contained that in view of the aforesaid position, the state, while recommending the case of demonstrator working under the university, could not have ignored the demonstrators working in government college, non-government colleges, as they are in the same footing. So it's a government stand that all of us are in same footing. Having taken this stand, Your Lordships, the court in this case quashed that order, saying that the order that you should withdraw all the scale, UGC scale of pay that you've given. And in fact, at para 9, this is what the order they did. It's only a notional fixation. Today, I only get pensionary benefits, nothing else. In view of the above, para 19, in view of the above, the court comes to the conclusion that since UGC has approved the pay scale of demonstrating tutors, they shall be given financial benefit as admissible by them. According to writ petition is allowed, it is directed the pay of scale of numbers of petitions association will be fixed notionally and annual increment will be allowed from 1/1/1986, but no financial benefit will be given from 1/1/86 to 96. Though they're going to be paid by UGC, but they're not going to give it to us. It is directed that the scale of pay of the tutors, that is so and so, and the scale of pay of demonstrators who have reached 2700, where the efficiency bar is to be crossed.
Since the SLP has been dismissed, you should get the same relief.
Luscious, the SLP is the following.
I know. So you're saying because it's been dismissed, you should get the same relief.
The dismiss. Now, even further, Your Lordships, other colleges also have got the benefit of 2 more orders of this court.
All right.
And Your Lordships, I have given another document, 2014 also, they have been processing that. That's there on affidavit, Your
All right,
Lordship.
let's hear them. Let's hear them. Yes.
Your Lordship, kind of paragraph 5 of our counter affidavit.
Yes.
Grant of UGC scale of pay pertains to granting aid which cannot be claimed as a matter of right as has been settled by the Honorable Supreme Court in Catena of decisions. In that view of the matter, the prayer of the petitioner for a direction to the opposite parties to implement the recommendations of the UGC.
No, you can't simply say policy decision. You have to say the basis on which you are discriminating. How can you simply say policy decision? Okay, what is the difference between the demonstrators in Utkal University and these demonstrators? Tell us that. What is the difference?
Well, these I have received just now. I have to cross check.
No. There's no question of cross-checking. You went in SLP against the Utkal University case. You in fact asked Utkal University not to give them the pay scales. They then protested, they came to this court, succeeded. You don't seem to have any in principle objection at all. Central government has been telling you, UGC has been telling you that you can give them the revised pay scale. Even in 2014, just see that first compilation she's handed over. Page 4, page 5. Just turn to page 4, Department of Higher Education writes to I'm directed to request you to furnish the following required information. List of demonstrators working. This is all fully aided colleges.
Your Lordship, grant short adjournment. I will
No. Why?
on
Why?
these
No, not go on adjourning like this. No.
But these documents have been filed today.
There are all internal. The one thing, compilations just judgments. The other are letters that you seem to have written. What we can do is we'll reserve orders. You file your note of arguments. Orders reserved. It will be open to the counsel for the state to file his written note of arguments within 1 week.
Weekly list item 39.
None appears. This was no perception.
Weekly list item number 40.
May I please? Item 39, I am appealing for the opposite parties.
All right.
Item 40.
Here, Miller, item 40, that land was acquired and award was passed long back in 2006, Miller. At that point of time, petitioner who purchased the land under Annexure 2, his title was under dispute. In the meantime, this honorable court has been pleased to hold that the land purchased under Annexure 2 is valid one. And in the meantime, Miller, the entire compensation amount, awarded amount has been paid to the opposite party now 3 and 4.
There are other provisions, sir. Writ petition that is not the remedy for this. You have to go under section 30, seek a reference.
Lord, Annexure 1, my application, that is, I have filed for reference when the writ petition was pending.
When did you file that application? What is the date of the award?
Date of award, Miller. Lord, 29/12/2008, Miller.
Award is 29/12/2008?
Miller.
Then how can you file 2 years?
But at that point of time, my title was under dispute. There was litigation before this court. I have placed before your lordship and flag B.
No, but have you applied to the concerned district court for reference?
No, Lord, I have applied.
He has not.
No, you have to apply there, sir.
Yes.
You have to seek a reference under 18 in the, and read with 30 in the concerned district court.
Lord, pursuant to Annexure B, your lordship, can have glance flag B. It is thereafter my title was held to be valid.
Whatever it is, you have to explain to that court, sir. You're in the wrong court.
Your lordship may allow.
Counsel, the petitioner seeks leave to withdraw this petition with liberty to approach the concerned court for appropriate relief. This post office withdrawn with liberty is faithful.
Weekly list item number 41.
May it please your lordship. My lord, there is a peculiar case where the SAP, non-sponsoring of the name of a SAP has been treated as an industrial dispute and reference has been made under section 10. Only two annexures your lordship will see to suffice your lordship to convince your lordship. Annexure 10. Your lordship may see that is the impugned reference. The terms of reference is, my lord, whether the action of the management of NTPS, TS, TPS, the present petitioner, Kanya is in not sending the biodata for a prerequisite for attending interview in case of Sri Kalakar Behra, OP number 4, for the post of artisan training electrical against regular post as a part of rehabilitation and resettlement measure in the regular process is legal and justified. What relief the workman is entitled. Now they have treated him as a workman here. Now your lordship may see annexure 3. That is the district administration's letter to the management of the petitioner stating that this OP number 4 is not an land oustee and he has been misrepresented as a grandson of the oustee. That is at serial number 5, your lordship must see. That is serial number 5, annexure 3, page 11, my lord. In the above, the letter is says such. Sir, in continuation of district office letter cited, I am to say that the case of 17 defective nominees out of 105 technical and non-technical SAPs having HSC and above were verified in response to minutes of the discussion of Commissioner cum Secretary Energy Department in dated such and such. In such verification, the status of the following 5 nominees appear to be defective as against the definition of the family defined in R&R policy. So here he is not an oustee.
His name letter placed before the tribunal.
No, well, that has been placed before the conciliation authority, before the labor authority, whereas it is not a dispute under the industrial dispute to drop that, but still then they have given.
My question to you is: did you show this document to the tribunal? What is where is the order of the tribunal?
No, my lord. Here the impugned reference is under challenge. Thereafter,
not the tribunal is not even started.
No, my lord.
And you've got to stay here.
Yes, my lord.
Oh.
So
yes,
because
the other side.
So I'm for the Union of India, but
the workman is not served. Kalakar Behra. Just find out opposite party number 4. What's the position? Since 2011, for 11 years, you've got to stay.
Reference at all was not maintainable because he's not an employee-employer relationship does not.
The arguments are all fine, sir. You just have to tell us, have you served opposite party number 4?
Yes, my lord. Notice has gone. I have already.
Sir, is there a difference between notice going and service?
Service has already been made because last date before he has appeared.
Complete. All right. You say, despite completion of service on opposite party number 4, none appears. The challenge in the present petition is to an order passed on 19th September 2011 by the Ministry of Labour, Government of India, referring the following dispute to the Industrial Tribunal for adjudication. Reproduce the scheduled portion in page 18. The contention of counsel to the petitioner is that the above reference itself is defective, since the person in question was found not entitled, was not found to be a land oustee in the first place, and therefore not entitled to any rehabilitation assistance at all. Attention of the court is drawn to a letter dated 26th May 2010, issued by the District Office Angul, issued by the Additional District Magistrate Angul, where it is stated that on verification of cases of 17 defective nominees for the rehabilitation assistance, 5 such cases, including that of the present opposite party number 4, was found to be defective. Full stop. Paragraph. Since there is no counter affidavit by opposite party number 4 to dispute the above contention, the court presumes the proceeds on the basis that the above factual position is correct. If indeed opposite party number 4 is not even entitled to job by way of rehabilitation assistance, since he does not qualify to be a land oustee, come by the question of referring a dispute concerning the failure of the management to send his biodata for attending an interview for the post of artisan trainee electrical as a regular post does not arise. Paragraph. That view of the matter, the impugned order dated 19th September 2011, sorry. Issued by opposite party number 2, referring the aforementioned dispute for adjudication is hereby set aside. The repetition is allowed in the above terms, no orders to cause.
Connected matter has been filed by the state, that is altogether a different matter. There the state government has challenged the award under annexure 1. For non-compliance of section 25A, the labor code was directed for reinstatement of the workman. And now the law is well settled that for non-compliance of section 25A, reinstatement cannot be automatic.
Yeah, it need not be automatic, but doesn't mean that it does not have to be there at all. Was there a stay passed by this court, sir?
Yes, ma'am.
On 20th May 2016.
Yes.
5 years after the award. 6 years after the award.
One line of the judgment.
No, whatever it is. Have you served the other side?
Yes, ma'am. They have already entered appearance and filed counter.
Who's appearing for them? The workman. Who's appearing for the workman? For opposite party number 2, what is the position?
Mr. B. Boral has entered appearance.
Prafula Kumar Das, huh?
Mr. B. Boral. The name is appearing in the cause list.
20,000, sir. Nothing.
No, reinstatement is there.
What is he? Ex-DLR, NMR?
Yes, DLR.
What is his age? He was 43 in 2011, sir.
Yes. Still 6 years service is there.
All right. Tell us on merits, what is the best position?
So, can you go to page 14?
Yes.
10th line from the top, you will also kindly see.
Yes.
The line starts with the management.
Yes.
The management is also silent about complying the mandatory provisions of section 25F of the Industrial Disputes Act. If there is a ban order of the government, it does not mean that the mandatory provisions of section 25F of the Industrial Disputes Act should be overlooked. The plea of the workman that he was working as watchman has no basis, but on the materials, it shows that he was working as NMR DLR. So now in this background, on careful consideration of all the materials available in the case record.
So that was not even his case. His case was that he was working as a watchman.
No, as a DLR.
No. The plea of the workman that he was working as a watchman has no basis.
Yes.
His plea was he was working as a watchman.
Yes. But all the records show that he was a NMR. On careful consideration of all the materials available in the case record as discussed above, I am inclined to hold that the action of the management in terminating the services of the workman with effect from 1/11/2003.
So you also accept he was working as NMR?
That is the evidence.
Then what's wrong in the case? What's wrong with the judgment?
Well, so far as the direction of reinstatement is concerned, because in this judgment also, while upholding the award of
but doesn't mean that an ordering reinstatement is wrong, sir. Well, it may happen that in a given case, in the facts and circumstances, they may decide a lump sum compensation is better.
Yes, in similar situation, you also, this is also facts are similar. You also kind of page 6.
For how long has he worked, sir? His termination is 1/11/2003. When did he start?
He worked
since 91.
91. No, that is his case, but our case is that he only worked for
12 years, sir. He has worked for 12 continuous years.
As per our record, he worked from 1/4/2001 to 2012/2001.
No, 91, sir.
So
Even
that is
your
which
record
case?
show he was engaged in 91. Just let's come back to page internal page 4 of the award, sir. Page 13.
Yes. MW1 deposits that the workman was working as NMR for the period from 1/4/2001 to 28/2/2002 only. And in support of it, he has filed a Xerox copy of the list of engagement of workmen along with Xerox copy of voucher for the period from 1/4/2001 to 2012/2001 under Jagannathpur section under Monijanga subdivision as NMR Mulya. The management has denied that the workman was working for the period from October 1991 to 31/10/2003. Further, according to the management, as per the ban order of the government, at exhibit B to D, the workman was disengaged from the workman. But the workman has filed a Xerox copy of letter dated 29/7/97 of the assistant engineer, minor irrigation subdivision by exhibit 1, discloses about the name of the workman as a NMR DLR engaged with effect from 93. In the same document, the name of the workman was found placed against the list of DLR for the year 1991. The workman has filed a Xerox copy of the certificate issued by the junior engineer Jagannathpur section regarding his engagement from October 91 to 30/4/1994. These documents are marked without objection. Furthermore, the management has not filed any document to show that the present workman was not engaged him from October 91 to 30/10/2003 as claimed by the workman. There is no explanation from the management for non-production of such documents.
So clearly, therefore, his document is more superior. He's able to show his engagement from 91. Your own junior engineer has issued a certificate of his engagement. Nothing in the matter, sir.
So that was for the year 1991.
Onwards, you yourself has produced documents from 2001. He has produced documents from 91.
No, exhibit 1 shows that he was engaged in 93.
Correct. After which your junior engineer has issued a certificate regarding his engagement from October 91 to 30th April 94.
Yes.
And you did not object to the filing of the exhibiting the document.
94 there is, after 94 there is no such document
No,
that he was engaged.
earlier, sir. Earlier.
No,
but the workman has filed Xerox copy of a letter above that. Just read that.
Yes, your lordship, 91. Well, if the claim of the workman is accepted, he was engaged in 1991 to 30/4/1994.
That is one document, sir.
Yes.
Above that, just go above that. But the workman has filed, but 5 lines above that. But the workman has filed Xerox copy of the letter dated 29/7/97.
Yes.
Discloses about the name of the workman as an NMR engaged with effect from 1993.
Yes. From 93.
No, and below that, sir, in the same document, you're not reading carefully.
No, if the
You're reading selectively. That's the whole problem.
No, I am placing again.
Read from the further according to the
further according to the management, as per the ban order of the government by exhibit B to D, the workman was disengaged from the work. But the workman has filed a Xerox copy of letter dated 29/7/97 of the assistant engineer minor irrigation subdivision by exhibit 1, discloses about the name of the workman as a NMR engaged with effect from 1993. In the same document, the name of the workman was found placed against the list of dealer for the year 1991. The workman has filed the Xerox copy of the certificate issued by the junior engineer Jagannathpur section regarding his engagement from October 1991 to 30/4/1994. So the certificate was issued that he was working from October 1991 till April.
That's more than 240 days, sir.
No, he's engaged. He was disengaged in the year 2003.
That's right. So he's working till then. He's working till then, sir.
No. That is the case.
You have to produce documents. What more can he produce?
From 94.
That he was disengaged in 94 and re-employed only in 2001. This is simply your say so. There are no documents.
That is our case only. That
No, you have to produce documents. That's what the tribunal is pointing out. You're silent about all of this. You see, the challenge by the management in the present petition is to an award dated 4th December 2010, passed by the Labour Court Bhubaneswar in Industrial Dispute Case number 42 of 2007. Paragraph. The dispute referred to the Labour Court for adjudication was as under. Take from paragraph. Paragraph. In order to substantiate his case that he had been engaged with the management as junior engineer in October 1991 and continued till 30th April 1994, the workman produced Xerox copy of a letter dated 29 July 1997 of the assistant engineer, minor irrigation subdivision, bracket exhibit 1, which showed his name as an NMR or DLR engaged with effect from 1993. Full stop. The same document showed him to be in the list of DLR for the year 1990-91. In addition to this, the workman produced a certificate issued by the junior engineer Jagannathpur section regarding the engagement from October 1991 to 30th April 1994. Paragraph. The case of the management was that the workman had been engaged as NMR only from 1st April 2001 to 28 to 2002. Full stop. Despite this, no document was produced by the management to show that the workman was not engaged earlier than the above dates, whereas the workman had produced documents which were allowed to be exhibited, documents to the contrary, which were allowed to be exhibited with no objection from the management. Paragraph. On an overall consideration of all of the above evidence, the Labour Court came to the conclusion that the workman had indeed continuously worked from 1991 onwards till the date of the termination of his services, that is 1st November 2003. Paragraph. Perusal of the impugned award reveals that the Labour Court proceeded on the evidence before it to come to the above conclusion. There is nothing perverse in the above analysis of the evidence by the Labour Court. Paragraph. It is then argued by Mr. Mudali, learned counsel appearing for the management, that the Labour Court ought not have awarded reinstatement, but could have awarded compensation, lump sum compensation in view of reinstatement. Reliance is placed on the recent judgment of the Supreme Court dated 2nd September 2021 in civil appeal number 4483 of 2010, bracket Ranbir Singh versus Executive Engineer PWD, bracket. Paragraph. In the present case, it is seen that the Labour Court accepted the case of the workman that he had been continuously employed by the management for over 12 years, that is from October 1991 till 1st November 2003. The above order of the Supreme Court in Ranbir Singh versus Executive Engineer PWD, bracket Supra, does not proceed to hold that there can never be any reinstatement as a relief for wrongful termination of services in contravention of Section 25 Cap F of the ID Act. Full stop. It is only an alternative means of providing relief. Full stop. By no means will a Labour Court's order directing reinstatement be declared to be erroneous only because it did not order compensation in lieu of reinstatement. So these are discretionary reliefs which are to be granted keeping in view the facts and circumstances of every case. Paragraph. In the present case, with the worker having put in 12 years of continuous service prior to the termination of services, it was not incumbent on the labor court to have only ordered reinstatement, ordered compensation and not reinstatement. In other words, the court finds nothing erroneous in the impugned order of the labor court, insofar as it is ordered reinstatement and a lump sum compensation of rupees 20,000 in favor of the worker. There is no merit to the present petition. It is dismissed. No order is to cause.
Weekly list item 42.
On behalf of Mr. S.B. Jana, there is no instruction.
No instructions dismissed.
Weekly list item 43.
None appears dismissed from opposition.
Weekly list item 44.
May it please your lordship, I'm on VC. May it please your lordship, I'm on VC.
Yes, yes.
The petitioners claim right over the land by virtue of a settlement made in the OEA authorities, which came to be revised, and the settlement was set aside by the revisional court. Now,
in all similar cases, we are permitting petitioners to withdraw and go to the civil court.
But here, the case is now covered by the Supreme Court's judgment of Siddha Matha, my lord. My lord is aware.
Right.
2016 judgment, and that judgment has also been followed by the division bench of this honorable court in several matters.
All right.
What my humble submission is, now the petitioner is in possession over the property by virtue of the status quo order passed earlier. So now what is happening is there are various schemes of Jagannath Temple, my lord, where they are considering the settlement or compensation as the case may be.
So you want to withdraw and go before them, you do that?
Yes, my lord. Yes, my lord.
Counsel, the petitioner seeks leave to withdraw this petition with liberty to approach the temple authorities for appropriate relief in light of the subsequent schemes developed, formulated. Dispose of is withdrawn with liberty is straightforward.
Obliged.
Weekly list item number 45.
None appears.
My lord. My lord, petition is Union of India, the Department of Archaeological Survey of India. The case is like this: two centrally protected monuments. One is the Sisireshwar temple, and another is Oital temple situated at Bhubaneswar. And it is declared since 1945 by way of Gazette notification under Annexure 1. My humble submission before your lordship, in view of illegal construction as well as in the unplanned drainage system, the entire monuments have been waterlogging, for which endangering entire this archaeological sites.
So you can't have a sweeping thing like this, sir. What is the particular site that you have in mind?
Yes, my lord. I have annexed the Annexure 2 series. I have given the map, my lord. Bital Daulo at plot number.
So you filed this petition in 2011.
Yes, my lord.
You're not interested at all, sir, in this. You're the archaeological survey, no?
Yes.
You're not interested. You're not interested in listing it, what happens in the petition, what happens at the site. You're not interested at all.
It was listed in 2015 and they listed in 2015.
14. Only once it is listed in 2014, sir.
Yes, man, that is. But facts now is that it is endangering the archaeological site is the fact now remains is that. And in view of series of construction is going on, and it is the duty of opposite party state government to implement the act, and
we'll simply say that, sir. We'll dispose of saying, please implement the act. You'll be very happy. Your archaeological survey, you're saying ask state government to implement the act. We'll dispose of saying implement the act. Correct?
No, my lord.
Then you will go away very happy.
No, my lord.
Why? Why?
That
you're not happy.
I'm happy that the state government will
implement the act.
Implement the act.
They'll implement the act. In fact, you have a consent order also, sir. He will also consent to implementing the act. You will also be very happy. He will also be very happy. We'll be very happy. One more case less.
In this particular case, your lordship may direct this state authority to constitute a committee to look after the drainage system for which it is endangering. And my
Why are you powerless, sir? You are archaeological survey, no?
Yes, my lord, in view of the act, it is we have.
Are you
given-
powerless? You cannot do anything at all.
Yes, my lord, only we will ask the state authorities.
Have you done that?
That is in view of the.
When did you do that, sir? When did you do that? You do not perform your statutory function, correct? You have statutory powers. You have a statute giving you statutory powers, correct?
Yes, ma'am.
You don't want to exercise those powers. You want only the High Court to do everything. Why?
We are making several requests before.
Where is that several? Which several, sir?
That in para 17.
No, no, para, no.
No document.
Show us documents, which is the several requests that you've made.
That we have.
Show us one document,
That has not been annexed.
Not annexed. Since 2011, have you made any request after filing this petition?
That, so far my instruction is concerned, he has given us several representations.
Don't have to, they have told you, sir, don't show anything to the High Court. Just tell the High Court we have made several requests. If the judges ask you, don't give them the documents.
I have not annexed the documents.
No need to annex.
That was the requirement at the time of filing of that was the requirement.
Then what do you want to do? You want to file a better petition? Sir, first, please exercise the powers you have under the statute. Have you exercised those powers? We are not clear. Very strange kind of petition this is. We've never had ASI file a petition feeling so helpless. Others are filing saying ASI is exercising all kinds of powers. Here ASI is coming forth saying, sir, I'm so helpless. There's a whole statute gives me so much powers, but I'm not able to exercise. Very strange, isn't it?
In this present petition, it has not been annexed and every document has not been given before your lordships. That is right. Since, but so far as
I don't know. If you want us to say all that I have said now, we'll say it in an order. If you want to say, sir, let me file a better petition, we can permit you. You decide.
With that observation,
What observation? What do you want to do?
For filing a better application.
Counsel the petitioners seeks to withdraw the present petition with liberty to file a better petition in accordance with law. This post office withdrawn with liberty is straightforward.
List item 46.
Lordship, the matter has become infructuous.
All right. Counsel the petitioner states the petition is infructuous. It is disposed.
List item 47.
No instruction.
No instructions. Disposed of.
List item 48.
My lord, in this matter, the assessment order is under challenge. I may be permitted to file an appeal.
Say the same thing. Seeks leave to withdraw the present petition.
My lord, delay may
with
be
liberty
condoned.
to file an appeal. If such appeal is filed not later than 9th May.
Yes.
Accompanied with an application for continuation of delay, citing the pendency of the present petition.
My lord, originals may be
as the
returned.
reason for the delay. It will be considered by the appellate authority in accordance with law. The originals of the annexures, the originals filed as annexures be returned, subject to being substituted by attested photocopies thereof.
Obligement.
The petition is disposed of.
List item 49.
None appears disposed.
List item 50.
My lord, 49, the council is not present. Kindly adjourn.
No, we are not adjourning, sir. You argue the matter. Where is your paper book?
My lord, I do not have the power.
We are not adjourning the matter, sir. Counsel the petitioner, counsel proxy. What's your name, sir?
Akash Acharya. Akash Acharya.
Mr. Akash Acharya appearing for Mr.
Pati. Counsel Mr. Pati.
Simply asks for an adjournment without even a paper book. Consequently, he is unable to even assist the court. Dismiss for non-prosecution.
List item 50.
Your Lordship, I'm appearing through VC.
Yes.
Lordship, it is only for modification of the order. dated 8/10/2012. In the meantime, we have paid the amount that as directed for, and the second appeal, which was pending by then, it is also disposed of, Your Lordship.
So there's no need for orders then.
No.
Or MC number
infraction.
17780 of 2012. Counsel to the applicant states that in view of the subsequent developments, she's not pressing the present application. It is disposed of as such.
Only that the payment is made may be recorded, Your Lordship.
She states that the payment has already been made and
That was a
therefore not
conditional payment, and already the second appeal has already been disposed of. So
All
that
right.
is infructuous.
That's what. All right.
Obliged, Your Lordship.
Passed over matter. Weekly list passed over matter, item number 15.
I may pardon to make a mention item 11 of the same list. I'm extremely sorry, my lord. It is non-appears. The similar order has been passed.
25 to 50,000.
Exactly, ma'am.
So same order.
May we supply that one?
Yeah.
Copy of
11 same order is that.
Much of it.
Kindly pardon my lords, item number 25. That is 25 months, the petitioner has died. Non-appearance, my lords dismissed it. In fact, the petitioner has died, my lords, in the meanwhile. Today's instruction I got it, my lords.
All right. Item 25, you say Mr. Mahapatra informs the court the petitioner has died.
Oh, he's died. Sorry. I'm appearing for in this case for State Information Commission. If he died, then substitution.
No.
That is, my lords, imposition of penalty under RTI Act.
How? What
While
is
he
the
was
penalty
Vice Chairman,
imposed?
Cuttack Development Authority, while he was Vice Chairman, Cuttack Development Authority, there's some order passed that.
All right, we'll waive that. What is the amount you asked to pay?
25,000 rupees. Now the children, my lords, they have to contribute.
All right, since the petitioner has died and the challenge is to the order passed requiring him to pay penalty. And considering that the said order has been stayed with this court for over 11 years now, the court does not consider it appropriate to burden his family with the said liability. Accordingly, the impugned order dated 20th May 2011 passed by the State Information Commissioner in SA case number 263 of 2008 is set aside. Right. The petition is disposed of.
Lordship, can you reduce some amount? Otherwise,
all the children, you want to chase the children. He has died.
Sorry. Sorry, it's all right. Sorry.
Yes.
My lord's item 17. Sorry, my lord. I couldn't appear.
Tell us what it is.
My lord, no instruction from the client.
So same thing. No instructions, dismissal, no opposition.
Item 14 was passed over, my lord. I am appearing for the state. Item 14, my lord. It was passed over.
No, not passed over, sir. Dismissal, non-passed.
Item 19.
Come to the mic, sir. Come to the mic.
My lord, item 19 is a matter that is, it has come against the order.
So we have to call out 15, sir. 15 is passed over.
15,
Item 15.
15, my lord, Mr. Mishra is in lex before court number 4. Your lordship can pass.
Can't go on passing over, sir.
He's in lex, my lord. He's in lex. I'm instructed to make a mention before lordship.
Very good, sir. Your instruction is perfect. You're also making perfect submission.
The order passed by
Can't go on waiting, no? We are also a court. No?
That is why senior counsel is engaged, but
so
deadlock, my lord, he's in court number 4.
So when will you have when do you think it appropriate to collect a paper book?
Pardon, my lord?
When will you think it appropriate to collect a paper book?
Paper book is with me.
Just bring it on that, put it on that table.
Yes, my lord.
Open it now. Let us read it together. What is the matter about?
Let the order passed by the Tahsildar Banki is under challenge.
Right.
Directing a suo motu case bearing number 164 of 2010.
Right.
Directing to record the name of the government in Khewat number 1 in respect of Khata number 2691 of Mauja Patpur and to record the name of Sri Lord Jagannath, BJ Puri, care of Temple Administration Committee Puri, by deleting the name of the recorded in column number 2 of the shared khata. My lord, the petitioners are the legal heirs, and all the recorded tenants have been died since more than 100 years and 50 years, more than 50 years. And without issuing any notice to them, my lord, the Tahsildar have decided the case as suo motu, where the petitioner's family has occupancy right over the lands for time decades. Therefore, my respected submission before your lordship at best, this order may be set aside and opportunity may be given to the petitioner's family to raise their objection and matter may be decided. This is the
Who's
only.
for the other side?
My lord. Notice, my lord, lordship may kindly see the noting, my lord. Probably due to non-filing of requisite, my lord, the notice could not be issued. They have to comply with the order.
It's all right, sir. They are the affected persons. Who is Krishna Chandra Mahapatra?
And it is one of the legal heirs of late Narsingh Mahapatra. There are 4 branches of the family.
Why has he been made an
Your
operator?
lordship may turn to page 7. Who are the recorded tenants, my lord? Page 7. I am reading, that is in Orissa. Bhagavan Mahapatra, Pita Mangovind Mahapatra, Purnachandra Mahapatra, Kismat Athona, son of Prithivas Mahapatra, Anancharan Mahapatra, Kismat Chariona, son of Bhikari Mahapatra, Narsingh Mahapatra, Kismat Chariona, Pita Gangadhar Mahapatra. Krishnachandra Mahapatra is one of the heirs of late Narsingh Mahapatra. The rest of the petitioners are not noticed. And the notice was given to Bhagavan Mahapatra, who died more than 100 years.
Page 15, lordship, see Annex 4, my lord. 3 orders are there, my lord. In the first order, my lord, peruse the report of RK Institute, a suo motu case for correction of ROR in favor of Jagannath Mahaprabhu Vijay Puri. It was initiated, my lord. Second order, my lord, this is put up today. Suo motu case bearing number such and such is instituted. Peruse the ROR bearing such and such. Issue notice to the recorded tenants to appear on 25/8 for hearing. On 25/8, my lord, this is put up today. Notice duly served and SR back.
The recorded tenant is present.
Is present.
Recorded tenants are died
Anyway,
since
this is an
100 years.
appealable order, no? This is an appealable order.
Yes, my lord. This is passed by the Tahsildar. Appeal provision is there, my
Your
lord.
lordship may, with that direction, your lordship may dispose of.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file an appeal against the impugned order of the Tahsildar Banki in accordance with law. If such appeal is filed not later than 9th May 2022, accompanied by an application for condonation of delay, giving the pendency of the present petition as the reason for the delay, it will be considered by the appellate authority in accordance with law. The interim order passed by this court on 26th April 2011 will continue till such time the appellate authority passes an interim order on an application to be filed for such relief along with the appeal, provided it is filed within the time stipulated. The appellate authority will proceed after hearing the present petitioners and any other person who may be interested in the plot in question. The court clarifies it has not expressed any view in the matter. The petition is disposed of in the above terms.
Delay, madam. There is little delay during the pendency of this.
You have not heard, sir, what to do. You will make me repeat the whole order again. You just dictated the whole thing.
Quickly list item 19.
19, my lord, virtually the matter is there. My lord, the dissolution of marriage and divorce was allowed at the instance of the petitioner. Then against that, the appeal was filed. In the appeal, while that appeal was pending, then section 24 petition was filed. In the section 24 petition, whatever the order was passed, that is impugned before lordships. And in the meanwhile, my lord, the dissolution of marriage and divorce was set aside, and against that this.
So this is infractuous, sir. So this petition is infractuous.
No, I would like to submit another things. But in the meanwhile, 125 petition has been allowed. So in view of that, he has been paid. That order, lordship kindly see.
No. What has that to do with this? This is a section 24 challenge, right?
Pending appeal.
That is all over, sir.
That is over. And, second
So
appeal
this
is
matter
filed.
doesn't survive. You say,
And
you
in
know,
the meanwhile, my
subsequent.
lord, this
Sir,
petition,
this we don't have to record in this petition. All this, sir.
Your Lordship, kindly see that order also, the interim order was passed by this honorable court that he has been paying that amount. And in the meanwhile, 125 petition has been allowed, so that my lord, this petition does not survive because
Counsel to the
125
petitioner states
is
that in
paying.
view of the subsequent developments, the present petition does not survive. It is disposed of as such. All interim orders stand vacated.
Week list passed on to item number 23.
May it please. May it please, ma'am. My lords. The present writ petition has been filed at the instance of a Sikh company, my lords, which was referred to the BIFR under the Sika Act, the then Sika Act, my lords. The facts are like this, my lords, that in 88-89, a loan of 30 lakhs was taken from OSFC. Thereafter, after 1 year, another 2 lakhs and 27,000. So total loan taken was 32 lakhs and 27,000. Now the unit was running. Suddenly, my lords, in 1996, for reasons not bona fide, neither germane in law, my lords, the OSFC, the running unit was seized by the OSFC. On the date of seizure, the outstanding interest was only 6 lakhs and odd, and the principal was 29 lakhs and odd. And my lords, the industry was run down to the ground by this seizure. They seized it and to stop. At that point of time, on the date of seizure, already repayment of more than 47 lakhs had been made on the date of seizure itself. Thereafter, my lords, another 7 odd lakhs was made. So total repayment has been made to the tune of 54 lakhs and odd, which is more than 150% of the loan amount taken. But I'm not getting into all that. Now, my lords, Sika, the proposal did not go through in the BIFR, my lords. So BIFR passed an order for winding up. While winding up was pending, the largest creditor, that is the State Bank of India, was settled, my lords, by the promoters. They settled OTS with the State Bank of India, my lords, more than 2.5 crores. And then, my lords, in 2008, Annexure 1, your lordship finds the no due certificate of the State Bank. That is Annexure 1, page 9. No due certificate given by the State Bank, my lords. Thereafter, my lords, in 2009, as per the extant existing scheme of the OSFC, the promoters approached the OSFC with the minimum deposit to settle on a OTS scheme, my lords. The requirement for that, for availing that scheme was deposit of, along with the application for OTS, my lords, proposal, a deposit of 10% of the outstanding principal. So therefore, 2,90,000 and odd was also deposited. That your lordship finds 2,97,000. Your lordship finds the receipts at page 16, Annexure 2 and 3, deposited with the OSFC. Now, 2009, the proposal was filed. It was kept pending till November 2010.
No, 1 minute. So this court stayed a BIFR proceeding.
AIFR proceeding. AIFR proceeding. BIFR passed an order of winding up that was challenged before the AIFR. My lords, AIFR admitted it, and AIFR for
Just come to this order dated 6th February 2008, passed by the court.
Which is this is in the other one, my lords.
Yes.
That was stayed because, my lords, there, my lords, what happened? The second written. Yes, I'll tell you, lordship, what has happened. During the pendency of the matter in the AIFR, my lords, on one day the local lawyer was late to attend the court by half an hour. So AIFR dismissed the matter for default. Against that dismissal, my lords, we moved the High Court saying that AIFR has no power to dismiss for default. So therefore, on that argument being made, the statute does not give it the power to dismiss for default. It has to decide either way on merits. That was the argument raised before this honorable court. So therefore, this honorable court stayed the order of.
No. So that second writ petition is over. There's no AIFR anymore.
No, now there's no AIFR. Now
Let's finish off that one.
Malad.
Say writ petition civil 1273 of 2008.
I would only pray for one thing, that EPCOL is a party in that. I may be given the liberty to approach the EPCOL for an OTS settlement. We are willing to settle with the OTS.
But if at all it is prevailing, because this
whatever
as on date of filing of counter
filed at a
affidavit,
stage when the Appellate Authority for Industrial and Financial Reconstruction (AAFR) had dismissed an appeal filed by the present petitioner for non-prosecution by the impugned order dated 7th December 2007. Now there is no AIFR, and consequently the present petition has been rendered infructuous. Consequently, the petitioner states that they may approach EPCOL for a settlement. It is clarified that it will be open to the petitioner to approach any of the creditors for a settlement.
Malards. Deeply over.
my only contention, my lord, Lordship, kindly record the dues as on date we had filed the counter affidavit, that may be reflected in the order, because he is asking for an OTS.
Sir, what will happen? Suppose we record that, what will happen? Suppose we don't record, what will happen? Nothing. Right? The petition is disposed of, all interim orders stand vacated.
In this matter also, I am appearing for opinion number 3, that is a State Finance Corporation.
All right, sir. 16114, just come to the prayer, sir. Mr. Palit, just come to the prayer in 16114.
161, that is the present matter.
Correct. Just come to the prayer. There's only one prayer, I presume.
Mallards. There's only one prayer.
Let's see what
my
understand.
limited, Mallard, it was on a very limited point. I approached the OSFC that your scheme is there. I want to settle your under your scheme. Here is my proposal. Here is your deposit as per the scheme. The deposit of 10%, that is also here. I'm depositing. You accept my scheme, I will repay your debts. Now they keep it pending. They reject it, saying that since you are in BIFR, we will, and some winding up order, so therefore we are not going to settle.
All right.
So my submission before your
prayer is that they should consider your application.
That manifestly arbitrary. They should consider my application. I will. Within a month, let them consider within a month.
What are you prepared to pay for them to consider?
Modified 2007 OTS, in fact, as a scheme is not available at present. So subsequently, what happened?
New schemes have been framed.
2011.
So what is it to pay for that scheme?
With the same clause.
Same clause, that is true, but let him pay one thing. I agree with my learned friend. Let him approach the board. Board will take his sympathetic decision with regard to the prevailing scheme, no problem.
All right. Counsel for the petitioner states that the petitioner is prepared to approach the board of the OSFC for settling the dues under the extant one-time settlement scheme (OTS). Learned counsel for the OSFC states that the OSFC will consider such application in terms of the, if made within a time, in a time-bound manner, in terms of the prevalent scheme.
What my submission is a sick company. My submission before your lordship is.
That's why you're going with an OTS.
That's the reason. Also under this the scheme under which I had applied, they had turned me down on the ground that on a manifestly arbitrary.
I've recorded a statement that they will consider your application.
2000
either on this or on that.
No.
2000 only on the extant scheme, on the existing scheme.
That scheme they could not have rejected me because I was ready to.
We can't revive a scheme, sir. Passage of time, we can't revive a scheme that is over.
My lords.
Also sympathetically, I say 2000.
You are introduced.
No. Just sympathy one should know. 2011 also rejected. Still, I say that he has approached the board, he will consider.
All right.
Can I only pray that your lordship, since it's a sick company, that may be taken into account?
No, that's okay. Since such application is made not later than 2nd May 2022, it will be considered in terms of the extent.
Only when it is a sick company. Otherwise, I would not have
communicated to the petitioner not later than 4th July 2022.
I would not have pressed for your lordship, my lords. I know my limitations. I would not have
Because
pressed.
whatever the scheme, you see,
one word,
we
my
can't-
lords, would not make a difference, my lord. One word would not make a difference.
No,
my
no,
lords.
it will
Just
be
as-
unnecessary. See,
it's a
otherwise
question of
you will
my
say
what.
that- no, you will come back in contempt saying they
No,
did not
no,
consider
no,
it
my
some-
lords.
Yeah, yeah.
I give an undertaking, my lords.
I don't need for all that then.
I give an undertaking, my lords. There will be no contempt here. Only, my lords,
It's not within the remit of the
it's going to
jurisdiction.
be a back-breaking burden. And it's
But
already a
beyond the
sick
scope.
company. It was run down to the ground. It's a running company, my lords. It was run down to the ground. I was ready
In
to
fact, the
settle
case
all of
laws,
them.
the case laws to the contrary,
I-
saying that
I-
we can't
I-
issue mandamus saying allow this
My lords,
OTS.
I
and
am
that.
not going into that arena, my lords. I am not
Correct.
even venturing into that arena, my lords.
All right.
Case laws. I was only praying your lordship may. Some latitude.
All adjectives, adverbs have
Some latitude.
have a meaning.
My lords, this has visited the Lok Adalat twice, my lords, on
Not
both
twice,
occasions.
not twice, more than that.
No, Lok Adalat twice, my lords.
No,
Both
no,
the occasions.
I know 5 Lok Adalat orders. I can show you that straight away.
2 orders. I have 2 orders.
No, no, we can show you more orders. It's there in the file.
My lords.
We just saw each of those orders.
Yes, my lords, on both occasions, at least 2 orders, the honorable judges had been very sympathetic to
That's
this.
right. That's Lok Adalat, even in fact, both of us, we can tell you. If your city is Lok Adalat, we'll
My
use
lords,
all those words.
I would bow down, my lords. I would bow down. This is a
In
sick
226, we don't use those
And
words.
my lordship may kindly observe the conduct of the company, my lord. Even in the sickness, the biggest creditor, the State Bank of India, has already been cleared, my lords. No due certificate. So it's not as if they are running away. That's the
You
bona
better say
fide.
nice things now about them. Otherwise, they will again reject your application.
That's the problem.
My lord, the bona fide of the company will be looked into, my lord. It is not that they are running away,
All right.
my lords. I deeply oblige.
It's disposed of in the above terms.
Weekly pastoral matter, item number 24.
And can I manage only one? All other factors may be taken into account while considering. All other attending factors, only that.
All right.
All other attending factors may be taken into account. I think I would be, my lords, I would be in my justified to pay for that at least.
Yeah, free to make a comprehensive petition listing out all factors which have
My
to be
lords,
taken into account.
that observation, comprehensive petition listing out all factors. That observation from my lordship would go a long way, my lords.
Also rejection of 2011 earlier also.
All right. Done.
Let's not take an approach of Shylock and the Jew, my lords. I still remember that.
All right.
Shylock and the Jew.
We'll take care. Don't worry.
All
My
right.
lords.
All right.
Oblige.
All right. Mr. Palid, I have one request. Just help your instructing counsel to get a proper gown.
My lords.
Help your instructing counsel to get a proper gown. All right.
I'm sorry.
No, it's okay. I have tried and failed. So I can request you.
It had not escaped. So my gown is all right. Man.
I know. Correct. All right. All right.
Item 24. Weekly list pastoral matter, item 24.
Before I am for opposite part number 4, I am appearing.
All right. Somebody asked for a passover.
I think they must have been regularized in the meanwhile. I think. Yes, I come across some names.
Let's see the last order. Class 4 employees of Puri municipality.
Yes, they were regularized.
Oh.
No, they were regularized then. Thereafter, pursuant to the direction of the government, again that was recalled.
Oh.
Because of the penal provision is there under section 73 of the Orissa Municipal Act, which says that without previous sanction of the government, there cannot be
Regularization.
So I think that in the meanwhile, they must have been regularized. Because,
I see. Whom are you for municipality?
I am for municipality, for OP number 4.
Okay.
That is why perhaps they are not interested to place the matter.
Despite a pass over none appears to the petitioners, Mr. Mantilan, senior counsel for the Puri municipality, states that in all probability, the petitioners may have been regularized. The services of petitioners may have been regularized by now. The petitions are dismissed, non-prosecution.
Both the reports.
Yeah.
Weekly list passed on to item number 28.
May I please, Your Lordship? Lord, I have prepared a date chart.
Yes.
And in addition to that, I have given an order passed by the same authority, taking a different stand and making liable the principal employer with regard to the differential minimum wages. My Lord, this petitioner, it's a proprietorship firm, and it is registered under the Orissa Shop and Commercial Establishment Act. The certificate is annexed to running page 18 of the brief.
No, just tell us, there's no interim order in this petition so far.
No, because at the stage of admission, since there is no private opposite party, the LEO Somoto instituted this proceeding under the minimum section 20 of the Minimum Wages Act.
Right.
Direction was given to serve extra copies on the learned ASG, and learned ASG also filed counter so far as OP number 3 principal employer is concerned. Though there is a noting in the cause list that OP number 1 and 2 have also filed their counter affidavit. I am yet to get a copy of that counter. Still, I would like to argue the matter.
No, in 19832, there are only two opposite parties.
3, Your Lord. 1 and 2, labor enforcement officer, and the RLC, the authority under the Minimum Wages Act. And OP number 3 is the principal employer. That ordinance factory.
No.
Under the Ministry of.
No. There is no opposite party number 3.
My Lord, cause title. 1 is labor enforcement officer.
I know the cause title that you've given us does not have the ordinance factory, although the ordinance factory.
General manager, ordinance factory, Badmal.
Oh, it's there, is it?
Yes,
All
it
right.
is there, Your Lordship. They have filed the counter. So also it seems from the noting in the cause list.
Oh, yes.
OP number 1, 2 have also filed the counter.
Correct.
But
OP number 3 has also filed. Correct.
Yes, I am yet to get a copy of that.
No. So if there is no stay order,
yes,
what have we been doing the last 10 years?
Since they are aware regarding pendency of this matter, thereafter they have not proceeded.
Oh.
Yes.
So they have not enforced it?
No. The Lordship.
So do we have to, is it not academic then? Because
no, Your Lordship, it is.
You are a proprietor. How many employees do you have?
No, that is not the issue, Your Lordship. This is a licensed security service providing agency. Your Lordship may kindly have a glance to running page 19. That's the authority under the Private Security Agency Regulation Act.
Right.
At page 19, Your Lordship, that registration license.
Right.
So when the OP number 3 floated tender at Annexure 3, there was no mention that to that establishment, if I supply this security guards, they should be paid central government minimum wages. There was no such indication.
Right.
So I, pursuant to Annexure 3, I submitted my.
So you've been given a 10-year-old contract, 10-year contract,
No,
is it? That contract must be over than whichever you got.
That period for
is
that
over, no?
That is over.
Then there is no stay order. The period is over. Then why are we entertaining this petition?
My Lord, only who is to pay that? Your Lordship, there is a specific prayer before the same authority to implead the management as a party, because unless until the principal employer pays me the minimum wages.
Anyway, they're not going to come after you in the last 10 years, no interim order. They don't seem to be worried.
They have appeared and filed counter, your lordship.
Correct. But they're not asking you to pay that minimum wages.
Ultimately, once it comes to this matter, since it is pending, they are not taking any action. Once it comes to an end, this pending litigation, now they'll try to enforce this impugned order. Unnecessarily, I'll be, your lordship, kindly have a glance to Annexure 4. My portion to Annexure 3 at running page 29. The submission of price bid for providing security service. And the rates are at page 30. These are as per the state government minimum wages notification, more than that, including PF ESI contribution. To ensure the statutory compliance, in addition to the minimum wages notified by the state government, I added those contributions to be payable to the security guards deployed by me. Then you also the acceptance tender is at Annexure 5, running page 31. There is no mention regarding this central government minimum wages. Then Annexure 6.
What is the difference between the state government minimum wages and central government?
For that period, around 4 lakhs amount. For that period, not hardly it was.
But Ordnance Factory is a central government establishment.
Your lordship, may kindly have a glance to Annexure 6 at running page 34. My lord, got it?
Yes.
Sir, with reference to above contract, 77 persons are to be engaged for watch and ward guard service of OFBL. It said in this connection, we are required to pay the respective individuals as per the Minimum Wages Act, latest gazette notification issued by the Government of India, Minister of Labour and Employment, and care should be taken to distribute wages of the guards in presence of so and so, so and so. Then the reply, my reply at page 35, next page. As per the, my lord, got it?
It's a statute.
My lord. As per the contract amount finalized, we will comply with the minimum wages of Government of Orissa, copy and close. The applicable to central government rate was not specifically mentioned in the tender inquiry document, and the rates approved was much less than the central government minimum wage basis. In case central government rate is to be paid, please accord sanction for same. So they didn't reply to this. Thereafter, this LEO visited the establishment of OP number 3 and noticed us. Thereafter, we made a further communication at Annexure 8, running page 36. You may.
Yes.
As per your letter number under reference subpara 1B, you had intimated this agency to pay as per the central government minimum basic wage to the security personnel deployed by OFBL. In reply to this, we had written to you as per our letter in subpara 1C to sanction and their own document annexed to their counter at running page running page 67, internal page 12 of their counter.
Yes.
My lord, got it?
Yes, please.
Clause 2. Services to be provided during the period of contract on all days, including Saturday, Sunday, and holidays. The agency shall deploy their guards round the clock on the basis of 8-hour shift, and weekly off shall be allowed to them as per statutory rules of Orissa government. During the weekly off day of guards deployed, the relief guard should be provided so and so. They refer to Orissa government rules. Then your lordship, their own clause, it does not disclose as to central government this at running page 71, internal page 16, clause 14. The agencies shall comply with relevant labor laws like minimum wages act, so and so, so and so. There is no mention regarding central government minimum wages.
Why should they mention, sir?
My lord.
This Ordnance Factory is a central government establishment.
And any, as your lordship knows, any contract contrary to statute is a void contract. So had they realized that my minimum wages quoted in the tender documents is less than the central government minimum, they would have outright rejected my application.
That's not
so they were much. So unless the principal employer pays me the minimum wages notified by the central government, where from I will pay them the minimum
You are
wages?
supposed to be aware of the law. Your bid amount should account for
The
that. sir.
bid document is not clear that I need
No.
to comply the minimum wage. And rightly, your lordship, I prayed before the learned authority to implead the principal employer as a party, and his observation may kindly be
No,
seen.
the principal employer is ordnance factory, right?
No, they didn't appear. They appeared, said that we are not necessarily in a proper party. They were not included.
Who, according to you, is the principal employer?
The OP number 3.
That's what. So they're there before.
They are liable to pay.
No,
your lordship.
They're
That
not
is the law. Your lordship may kindly have a glance to section 21(4) of the Contract Labour Regulation Abolition Act.
Or
Section 21(4).
Contract Labor Act, please.
Contract Labour Regulation Abolition Act 1970. Section 21.
Yes.
Clause 4. In case the contractor fails to make payment of wages within the prescribed period or makes short payment, then the principal employer shall be liable to make payment of wages in full or the unpaid balance dues, as the case may be, to the contract labor.
That's right. Only if you fail.
Yes.
Why should you fail?
But here the failure was because of the reason that they did not pay us.
You're only questioning. You're not yet failed to pay.
My lord.
Once you fail to pay, then this will happen.
My lord, may kindly have a glance to the order passed by the same authority, which was not with me, but there is a pleading to the said effect that I beg to reserve my right to produce that order.
All right.
That order was passed by the same authority on the very same day on which the impugned order was passed.
Right.
Kindly have a glance to that order. That has been flag marked.
Yes.
Order. That is application number MWA 97 of 2010.
Right.
The Labour Enforcement Center, Bhubaneswar, and the Inspector under Minimum Wage Act filed the present claim application under Section 22 of the Minimum Wages Act 1948 on 28/4/2010 against the above named OPs for realization of an amount of rupees so and so in respect of 7 workmen on account of less payment of minimum wages for the period from.
So that is the 21(4) in implementation, sir.
My lord.
They are implementing 21(4). This
No,
is
my
an
lord.
order in implementation of 21(4).
No, your lordship, that is not 21(4). That is that was application for this differential payment.
Correct.
Under Section 22, same Minimum Wages Act authority has passed this order.
All right.
My lord. Subpara 2. The applicant OP both were present. Here in this case, the contractor did not appear. The principal employer appeared on being noticed.
That's the
and the
problem.
principal employer was directed to make such a differential payment. In addition to that, penalty was also waived out on the ground that is a central government undertaking. Whereas in my case, though no payment was made by the principal employer, enabling me to pay the differential minimum wages in terms of the central government minimum wages, though admittedly I paid the minimum wages in terms of the state government minimum wages, even more than that. And so far as differential, your lordship, the applicant was directed to prove the application. The applicant states that the OP was carrying out the work of providing security service, same, sweeping so and so. And the said OPs are the employers in terms of Section 2E of the Act. Then your lordship, the operative person, the OP number 2 prayed before the authority to waive the compensation against the prayer of the applicant as the Regional Research Institute Homeopathy, Government of India organization or the Ministry of Health and Family Welfare Department, Ayush. After hearing the applicant and going through the documents, I found that the claim of rupees 2,10,000 so and so rounded to next higher up to so and so is established against the OP beyond all reasonable doubts, and therefore I award this claim of rupees so and so only. The authority does not find it expedient to award compensation on the pleas Regional Labour Institute Homeopathy Government of India organization under the Ministry of Health and Family Welfare, Ayush. I therefore pass on no award for payment of compensation. The OP number 2 is directed to deposit the claim amount by way of demand draft in favor of the concerned workmen and deposit the same with the applicant, that is Labor Enforcement Officer Central Bhubaneswar 2. The applicant is directed to disburse the DDs to the concerned workers and submit report. The OP1 is a contractor under the established OP number 2. I find that workers have suffered economic injury on account of the late payment of minimum wages and needs to be compensated to meet the ends of this. Therefore, I award compensation to be paid at OP number 1 at the rate of rupees 500 each, which comes to rupees 5,500. OP1 is directed to deposit the demand draft. Your Lordship, may kindly have a glance to the impugned order in my case at Annexure 1, running page 15. What was his observation when I prayed that the principal employer should be added as a party? That at running page 15. The applicant and OP both were present on the date hearing. The applicant was taken up for hearing on 4/8/2010. Applicant and OP were present. The hearing was concluded and reserved for orders. The OP's representative submitted the memo of citation so and so in order to give opportunity to the OPs to put forth his views on the issue. Hearing was adjourned to 29/10/2010, making the party the general manager, Ordnance Factory Badmal, on 29/10/2010. During the hearing, the representative of OP, that is principal employer, though appeared, submitted that the matter may be dealt only with the contractor as principal employer, do not come within the ambit of Minimum Wages Act. Since the contractor has already left, it is not possible at this stage to comment anything on this subject. He further prayed before the authority that there is no scope to make a party to the principal employer in the Minimum Wages Act. Hence, the Ordnance Factory Bamul may be kept out of the ambit of this case. This is perverse and contrary to the provisions under the Minimum Wages Act, Section 2E, which defines employer. Section 2E means a person who employs, whether directly or through any person, or whether on behalf of himself or any other person, one or more employees in any scheduled employment in respect of which minimum rates of wages have been fixed under this act and includes except in subsection 3 so and so. So here the principal employer also comes under the ambit of, it is not that to all the establishments where the contract laborers are being engaged, Minimum Wages Act is only applicable to contract laborers, not the principal employer. So unless until the principal employer ensures making payment to the contractor, the minimum wages applicable to the said establishment, the contractor cannot make such a payment, Your Lordship. And rightly, it has been well demonstrated from the correspondences made between the parties, which were exhibited as Exhibit 1 to 3, that they failed to establish that there was a clear-cut mention in the tender papers that we need to comply the minimum wages notified by the central government. They failed to establish that. And they didn't, they were not added as a party before the authority, though such a prayer was made. And my show cause filed before the authority was also quite exhaustive, taking note of all the points agitated before the authority, but authority did not take any steps to impede the principal employer to ensure the minimum wages notified by the central. Because my establishment is registered under the state acts, and I was ensuring payment of state minimum wages to the workers. And I was under bona fide impression that I should pay my employees the minimum wages notified by the state government. Until it was so demanded by the LEO.
So the challenge with the present petitioner, which is a proprietary concern registered with the government of Orissa Home Special Section Department and licensed in the business of private security agency, is to an order dated 12th May 2011 passed by the authority under the Minimum Wages Act 1948 (MW Act) and the Regional Labour Commissioner (Central Bhubaneswar) in application number MWA/62/2009. By the said impugned order, the petitioner was asked to deposit compensation of rupees 475,015 apart from the minimum wages, prescribed minimum wages,
differential minimum wages
payable to the workers engaged by the petitioner to render services at the ordnance factory, at the premises of the ordnance factory. Badmal, District Bolangir, Orissa, which worked out to rupees 475,015. Full stop. Consequently, the total amount required to be deposited by the petitioner in terms of the impugned order was rupees 950,030. Paragraph. Although the present petition was filed on 25th July 2011, it was listed just once. It was listed for the first time only on 6th April 2015. Full stop. Thereafter, on 16th April 2015, notice was issued to the opposite parties. Full stop. No interim order has been passed at any stage of these proceedings, although the present writ petition has been pending for over 11 years. Paragraph. At the outset, Mr. Mishra, learned counsel appearing for the petitioner, states that although there is no interim order passed in the present petition, till date no steps have been taken by the opposite parties, that is the Labor Enforcement Officer, bracket opposite party number 1, and the Regional Labor Commissioner Central, that is opposite party number 2, to have the impugned order enforced. Paragraph. Mr. Mishra submits that pursuant to a tender call notice issued by the opposite party number 3, inviting bids for deploying private security guards, the petitioner submitted a price bid on
Dates are in the date chart.
Yeah. Full stop. According to the petitioner, in the said tender call notice dated 23rd August 2008, there was no mention that the petitioner was required to pay minimum wages to the security guards as per the notification of the central government. Full stop. The petitioner states that when submitting a price bid on 14 September 2008, the petitioner bona fide understood that the petitioner was required to pay minimum wages as notified by the state government in respect of the 71 security guards to be supplied by the petitioner at the rate of rupees 3189 per head, including statutory payments, deductions to be made and deposited with the Provident Fund and ESI authorities. Paragraph. The petitioner's bid was accepted by a communication dated 22nd November 2008 of the opposite party number 3. Full stop. Pursuant thereto, security guards, supervisors, and inspectors were supplied by the petitioner to opposite party number 3, to the establishment of opposite party number 3. Paragraph. On 22nd December 2008, the works manager of opposite party number 3 wrote to the petitioner asking it to pay the individual security guards deployed in the establishment of opposite party number 3 minimum wages as per the latest notification issued by the Government of India, Ministry of Labour and Employment. Paragraph. Replying to the said letter on 7th January 2009, the petitioner took the stand that due to non-mention in the tender call notice of the petitioner's requirement of having to pay minimum wages as per the central government notification, the petitioner would not be in a position to make such payment unless sanctioned was granted for such payment. In other words, the stand of the petition has been that the differential minimum wages ought to be paid only by the principal employer, that is opposite party number 3, and not the contractor, that is the petitioner. Paragraph. After the labor enforcement officer, bracket central, bracket opposite party number 1, visited the establishment of opposite party number 3, a communication was sent by it on 15th May / 10th June 2009, enclosing a calculation sheet pertaining to the differential amount of minimum wages with regard to the 102 persons supplied by the petitioner, 99 of whom were security guards and 3 of whom were gunmen. Paragraph. Petitioner then wrote to the opposite party number 3 on 23rd June 2009, asking opposite party number 3 to release the arrears of the minimum wage to the tune of rupees 742,453. Full stop. Meanwhile, MWA case number 62 of 2009 was instituted by the labor enforcement officer by opposite party number 1 before the authority under the MW Act against the petitioner, in which notice was issued to the petitioner. Full stop. The petitioner then filed an elaborate reply to the said show cause notice, taking the same stand, namely that the petitioner was not liable to pay the minimum wages in terms of the central government notification, since that was not mentioned as a requirement in the tender call notice. Paragraph. As regards the request of the petitioner before the authority under the MW Act that OB number 3 should be implemented as a party, the authority implicitly declined
That was only reflected in the impugned order, not any interlocutor order.
Impugned order noted the views of the General Manager, Ordnance Factory. That the principal employer is not within the ambit of the MW Act. Paragraph. Mr. Mishra refers to section 21 bracket 4 of the Contract Labor bracket Regulation Abolition Act 1970, in terms of which the principal employer is liable to make payment of wages in full or the unpaid balance as a result of the failure of the contractor to make payment of wages or making short payment. Paragraph. He also referred to
Section 2E of the ministry.
Section 2 bracket
E. Section 2E. Employer.
bracket small e of the Minimum Wages Act of the MW Act 1948, which defines employer as under reproduce.
The Roman 2 is important.
Yeah.
Many scheduled employment under the control of the government of India. In India.
Yeah. Say refers to 2E bracket 2. The contention is that in the present case, the requirement to pay the differential minimum wages is that of the opposite party number 3, that is the principal employer and not the contractor, particularly since the tender call notice made no such mention of the requirement of the contractor having to pay it. Reliance is also placed and an order passed by the same authority under the MW Act in another case being application number MWA/97/2010 dated 12th May 2011, where the liability was fastened by the authority not on the contractor but on the principal employer.
Averment to the said effect is at para 3.14 of my writ application, internal page 8. Para 3.14, internal page 8.
Paragraph. The above submissions have been considered. Full stop. The liability to make payment under the MW Act is a statutory liability. Full stop. As part of the terms and conditions of the tender notice is clause 14.
Scope of work is at your lordship, running page 65, 67, or internal page 12 of their counter.
No, 1 minute.
So Orissa.
1 minute,
rules.
sir. 1 minute. 1 minute. Just be patient with me.
Sorry.
If you do not mind.
Sorry. Extremely sorry.
You'll have to be patient with me, sir. Which reads as under. The petitioner, while submitting a price bid, was expected to be conscious of all the prevalent labor laws, and that included the MW Act. Full stop. Beyond this, there was no requirement that in the tender notice it should be specifically mentioned that the contractor would be liable to make payment of MW, minimum wages, as per the central government notification. Full stop. The petitioner is fully conscious that opposite party number 3 was a central government undertaking to which the central government notifications under the MW Act would apply. Full stop. It is therefore not acceptable. No, it is not possible for the court to accept the plea of the petitioner that he bona fide believed that he was liable to make payment only as per the state government notification under the MW Act and not the central government notification. Full stop. Paragraph, it was then argued by Mr. Mishra that if the price quoted by the petitioner on the basis of the central government notification was found to be unacceptable to opposite party number 3, then opposite party number 3 ought to have rejected the bid. Full stop. This plea does not advance the case of the petitioner one bit. The petitioner, having submitted a financial bid, was expected to be aware of what the liability was, what the statutory liabilities were. Full stop. It was not for opposite party number 3 to advise the petitioner what its price bid should have been. Paragraph. The liability, as regards the liability under the Contract Labor Regulation and Abolition Act 1970, shifting to the principal employer is concerned, the wording of section 21, bracket 4 is instructive. Full stop. Section 21, bracket 4 reads as under, reproduce that. The liability shifts to the principal employer only if the contractor, open quotation, fails to make payment of the wages. Full stop. In the considered view of the court, that stage is yet to be reached. At the stage when the petitioner is required to make those payment of such wages, the petitioner has approached this court, challenging the demand made. Full stop. It is only after the demand is confirmed by the dismissal of the present petition and the petitioner continues to fail to pay the required amount that section 21, bracket 4 of the Contract Act would come into play. Full stop. The argument based on the definition of who the employer is for the purposes of section 2, bracket E, bracket small 2 of the MW Act also does not help the case of the petitioner, since clearly it is pursuant to a labor contract that the workers have been supplied by the petitioner as an agency to work in the factory of opposite party number 3. And in terms of the tender conditions, the liability to make payment of wages is clearly on the petitioner and no one else. Paragraph. Consequently, the court is not persuaded by any of the arguments advanced to assail the impugned order of the authority. Paragraph. The case, the decision of the authority in application number MWA 97 of 2010 appears to have turned on its own facts. The question there was not of any differential wages between the minimum wages payable under the state government notification and that under the central government notification. We'll stop. Moreover, in that case, the contractor chose to remain ex parte. We'll stop. Therefore, the said order is clearly distinguishable on facts. For all of the aforementioned reasons, the court finds no reason to interfere. The petition is accordingly dismissed.
Weekly pastor matter, item number 34.
Item number 34, I may be permitted to withdraw.
Counsel, the petitioner seeks leave to withdraw the present petition. Dismiss this withdraw.
Item 35.
35 also permitted to withdraw. Madam.
Seeks leave to withdraw the petition.
Supplementary list, fresh admission, item number 3.
None appears. Dismissal not possible.
Supplementary list, item number 4.
None appears. Dismissal not possible.
Supplementary list, item number 5.
Item number 3, Your Lordship. I'm on VC. I may be
Yes.
pardoned.
Yes.
I missed it. Your Lordship, the prayers become infructuous. Your Lordship. I may be permitted to withdraw.
All right. 3 say infructuous, permitted to withdraw. Yeah.
Supplementary list, item 5.
May I please? Well, this is a PIL matter. The people of the village afraid to withdraw that a project. The Lordship may kindly see Annexure 1, my lord. The RR.
Page 14. And the plot number is 9 at page 15, my lord.
This pipe water supply must already be there, sir.
Yes, my lord. Yes, my lord.
It is already there.
There's a mega pipe water
Mega
supply, my lord,
pipe.
project. It is covering 91 gram panchayats and 526 villages.
Right.
The date of commencement was February 2019 and date of completion February 2021. So it's already
over.
completed, my lord.
Yeah, it's already completed.
May not be complete, my lord.
No, he's saying it's completed.
Date of completion was 14/2/2021.
No,
24 months.
till now it is not complete, my lord.
What's the status, sir?
My lord, status, this is the first time it has come. If you not pass with it.
All right. Council of the State will inform the court of the current status of the project. List on 26th April.
Obliged.
Supplementary list item number 6.
My lord, item 6 and 7, in both the cases, the state government is challenging the order passed by the Lord and Tribunal. My lord. The matter relates to grade pay, my lord, under RSCP. Similar such matter have been admitted, my lord, WPC number 11713 of 2018. WPC number 11713 of 2018. That is the lead case.
No. Lead and all is fine, sir. But please tell us, you're challenging an order of 2017.
Yes, my lord. The judgment which has been relied upon by the Lord and Tribunal, that is OA number, my lord, 2576 of 2016, that has been challenged before this honorable court, and this honorable court stated that, and the matter is in session, my lord. The judgment which has been relied upon, my lord, that is the judgment under challenge before this honorable court. So what I pray, my lord, let this case be tagged to the batch of cases under RSCP, my lord. The lead case being 11713 of 2018.
Achha, how is this case before this bench?
It's
not a PIL, no?
No, my lord. These are all orders passed by the Lord and Tribunal in a way, my lord.
It's a list before the assigned bench. On. List before the assigned bench on 18th April. 18th April, it will come before the assigned bench.
Yes.
Both 6 and 7.
In item 7, I'm appearing. Kindly allow me, Your Lordship.
You have to be louder, sir.
Your Lordship, I am appearing in item 7, my lord.
All right. We'll go before the assigned bench, sir. Right.
Okay.
Supplementary list item number 8.
Item 8, may I please, Your Lordship? This matter relating to include the petitioners to the old GPF rules and 38 and OCS rules 1992 and to migrate to them from NPS to GPF.
1 minute. Why is this also before this bench?
Similar matters, my lord.
No, but why is this bench? List before the assigned bench. It's a judicial service.
Yes.
Achha. Which are similar matters?
My lord. That's adjourned to 19th, my lord. 19th April.
9th April. Okay. List on 9th. All right.
Supplementary list item number 9.
May I please, Your Lordship? My lord, in the case, the village jungle, Gramya jungle has been encroached by some encroachers. I have given the ROR. Your Lordship may kindly come to page 29.
Who are the intruders, sir?
My lord.
Who are the intruders? 5 to 8.
My lord.
File the representation.
Representation, Your Lordship.
Annexes, my lord. Page 38, P4 series. To the collector pool.
Where is the proof of service of this
My lord.
Lord, the postal receipt, all right. The petitioner's representation dated 28 August 2021 shall be examined by the collector Puri. And after notice to the petitioners and to opposite parties 5 to 8, and after giving them a hearing, a reasoned order should be passed thereon not later than 1st August 2022 and be made available to the parties not later than 8th August 2022. Court clarifies it has not expressed any view in the matter.
Supplemental list item number 10.
Item 10, my lord, I have filed a wakalatnama in DC, my lord. I filed a wakalatnama yesterday for this matter. My lord, may kindly see the Supreme Court's ordered flag X.
Yes.
Matter has been restored to the file of the High Court for disposal and merits, my lord. And since this needs to be adjudicated afresh, I have filed a fresh wakalatnama. But perhaps the matter is not of this bench, my lord. This is challenging the award of the industrial tribunal.
No, since a 2009 matter, probably it's in this bench. That's why. Why don't you carry on?
There are certain amendments. There is no counter affidavit filed in this matter when it was disposed of last. So the matter.
Where is the Supreme Court order? What is the date of the Supreme Court order?
This is March 7, 2022.
All right. Good. Take water. The court has perused the order dated 7th March 2022 passed by the Supreme Court of India in Civil Appeal number 1889 of 2022, by which the earlier order dated 17 December 2019 of this court has been set aside, and the present writ petition has been restored to the file of the court, of this court, for a fresh hearing in accordance with law. There are other petitions pending, is it?
No, my lord. There are no other petitions.
Just come to this order of the Supreme Court.
My lord.
If you read the second page, the second paragraph, we have gone through the impugned order. Particularly without examining inter se rights of the parties arising from the pleadings of the petitions pending before the court since 2009. Or do they mean this petition?
This petition, man.
There are no pleadings according to you.
Pleadings, the writ petition has been filed, but there was no counter affidavit that is on record. So when the order was passed, it was probably not passed on the counter.
You will file your counter now.
No, my lord, I am the petitioner. I am challenging the order. The counter is to be filed with the opposite parties in this case, 2009.
Right. No, but there are no pleadings if they have not filed a counter.
That's exactly what I believe the Supreme Court has said. That it has to be disposed of.
You are for the workmen.
I'm for the opposite party, Your Lordship.
So you'll file your reply now.
My Lord, there is no instruction from the client, so this matter.
All right. One of the grounds on which the Supreme Court has set aside this court's order is that the single quotes, the pleadings of the petition, unquote, were not examined. Stop. It transpires that no reply has yet been filed by the opposite party to the present petition. Counsel for the appearing for the opposite party today states that he will have to seek instructions. Paragraph. Reply, if any, to the present petition be filed by the opposite party
I have one submission, my lords. My lord.
Within 4 weeks, and a rejoinder, if any, be filed thereto before the next day.
I have one submission, my lord. May I make the submission?
Yes, yes.
My lord. The writ petition, when it was filed, I was not the counsel. This writ petition needs amendments, my lord. To certain
All right, you can
facts
file an
that-
application. Nobody stops you, sir. You file an application for that. List on. Whenever you file an application, that will come up separately.
I was wanting to, my lord, proceed, my lord, to allow me to withdraw this and file afresh instead of making an amendment, because that will.
Oh.
That is,
all right, then you should roll the Supreme Court instead.
There's no problem in favor. The amendment will just make it more tenuous, man. Because
All
I have
right.
to file a consolidated petition.
All right. You say counsel for the petitioner states that a fresh petition would have to be filed by the petitioner to incorporate certain changes instead of amending the present petition. So accordingly, the petition is permitted to be withdrawn with liberty to file a fresh petition in accordance with law. Petition is accordingly disposed of. All right.
Supplementary list item number 11.
Your Lordship, I am in virtual manner. Lordship, there are two appeals. In this case, under Section 21 of Coal Bearing Areas Act. In this case, my lord, notices were issued to the substituted legal heir, my lord. So, noting is that notice has held sufficient against them. So, it is, if they appears, then it will be fixed for final hearing.
No, it's a 2016 matter. We are now finally hearing only.
Your Lordship?
We are only finally hearing only. You can proceed. If they have been served, you proceed with the matter.
Your Lordship, my lord, in this case, my lord, that this is two appeals, my lord. Two appeals, MFA number 1 by 2016 and 2 by 2016. My lord, that arises that the order that is under Annexure 1, this is the impugned in this appeal, my lord, that passed by the Coal Bearing Tribunal, my lord, your lordship, your lordship may kindly see the date chart, short date chart that itself I have mentioned in my appeal memo, my lord. Your lordship kindly turn to MFA 1, my lord. I am holding the MFA 1, my lord, your lordship, page 9, my lord. Am I audible, my lord?
Yes.
Your lordship, page 9 of my appeal memo. That starts with para 10, then your lordship come to page 10.
Yes.
Page 10. That 16/12/1953, the suit land along with other land measuring 22 acres something 30 decimal were acquired by Dubraj Patel who had registered gifted. This is the admitted case, my lord, which I have mentioned. Then 10/1/1987, the central government issued preliminary notification under Section 4(1) of the Coal Bearing Act, giving notice to the intention for proposed for coal over areas including the suit land. Then, 26/9/1989, central government issued notification under Section 7(1) of the Act, disclosing its intention to acquire the notified land. Thereafter, the central government issued declaration now under Section 9(1). Then thereafter, lordship, 33/93, central government issued notification under Section 11 of the Act, vesting absolutely all rights in the acquired land on the NCL, respectively, with effect from 17/11/91. Thereafter, this date is relevant, my lord. 13/7/95, the original recorded owner, Dubraj Patel, the case land is a self-acquired property of Dubraj Patel. It is admitted, my lord. Willed over the suit land in manner aforesaid in favor of the applicant under Annexure 4. The appellant, my lord, that the two sons of Dubraj Patel and the private respondents that are daughters of the Dubraj Patel, my lord. So therefore, my lord, the appellant and the private respondent, all 6 persons are legal heirs of Dubraj Patel. It is admitted. Then thereafter, lordship, 9/1/2003, the suit land was mutated and a mutation ROR was issued in favor of the appellant. Then 12/9/2006, MCL motion for a denotification that was ultimately Supreme Court ordered disbursement of compensation. Then claim 6/6/2012 claim commission appointed in pursuance of the order verdict of Supreme Court. Then 8/6/2012 some of the respondents file objections. They are claiming that the press notice indicating payment of compensation. They objected towards payment of compensation, that the compensation is low. Therefore, appellant file objection and private respondent also filed objection. Then 27/6/2012, the appellant filed their objection under Annexure 9. And 5/9/2013, some of the respondents moved the commission for getting compensation in respect of 3 acre 52 decimal, my lord. My lord, I maybe clarified this thing, my lord, that they sued land in total 22 something, that by virtue of will, appellant number 1 got 3 acre 52 and the rest 15 decimal by virtue of will, that is to be distributed among appellant number 1 and 2. That is the will, my lord. Then thereafter, your lordship, 352 already that commission granted compensation and disbursed in favor of appellant number 1 by virtue of that will under Annexure 4. Then 1/10/2013, the commission did not entertain such claim of opposite party. Then some of the respondents filed CBI number 16/2019 before claim tribunal. This starts from claim tribunal, my lord, issue starts from this date, my lord. So claim was filed by private respondent as well as appellant. Then 5/12/2013, appellant number 1 was paid compensation for his gifted property measuring 3 acre 52 decimal by claim commission in pursuance of the compensation rule prepared by the claim commission, which has been filed before this Honorable Supreme Court. But the compensation in respect of residual, that is acre 15.73, that is of gifted property, the nature of the respondent number 2 to 7 featured in the recipient list. 2 to 7 means daughters of original owner. Then 5/5/2014, the appellant again filed claim before the coal-bearing tribunal constituted under section 14(2) of the Act under Annexure 2 in TC number 15/2014, praying to disburse the amount in respect of 15 acres 78 decimal awarded in favor of the respondent number 2 to 7 exclusively in their favor on the basis of will. Thereafter, my lord, impugn order under Annexure 1 was passed. Your lordship may kindly see Annexure 1. That Annexure 1 was passed, that sum and substance that your lordship may finding of this, page 26.
Yes.
My lord, page 26, that is para 8, my lord. The admitted facts.
Yes.
The admitted facts are Khata number 29 of Nadia Garjan Bahal has been acquired by the MCL after proper notification, and MCL has issued notice to pay the compensation to all the legal heirs of the recorded owner Dubraj. It is also admitted that a portion of the compensation determined has been paid to Virendra Patel, means appellant number 1, my lord, and the balance has been deposited with the ADM Sundargarh. The parties do not dispute the genealogy as mentioned in TC number 16/2013. My lord, two petition was filed, one TC number 16, that is by daughter, and TC number 15 by sons. And that Dubraj died in the year 95. I'm leaving behind 2 sons and 4 daughters of his legal heirs and successors. Whereas the petitioner of TC number 16/2013, being the daughters, are claiming 1/6 share of compensation amount. The petitioner of TC number 15/2014 are claiming the entire compensation amount to the exclusion of all other sons and daughters of late Dubraj on the strength of the will executed by late Dubraj. B2 think the properties in their favor in total except 3 decimal of land previously gifted from the state khata. Then
you are appearing for the sons.
Lord, I am appearing from Mahanadi Coalfields Limited, open number 8
No,
in the first place.
Madam, you are appearing for the sons.
I am appearing for the appellants.
Are they the sons or who are they?
Your Lordship, sons.
They are the sons.
Sons.
So they don't want to give the sisters their 1/4 share, 1/6 share.
No, my lord, my submission before your lordship that by virtue of will, my lord, I am both the appellants are owner of the that property.
No, the will is probated.
Your lordship.
The will has been probated.
Your lordship, that I am coming, my lord. It is not disputed. It is already mentioned that this in this Sundargarh district that will is not required to be probated.
No, but it will be contested. No, it is not an accepted will.
Yes, only my lord, genuineness of the will that is to be examined, my lord. Only genuineness, my lordship. Because probate is not.
How will this tribunal under the Coal Bearing Act do all that?
Your lordship, that your lordship may kindly say section 26, my lord. 26 of the act, your lordship.
Coal Bearing Act.
Section 26 ostate the jurisdiction of the civil court, my lord.
No. That's for the purposes of examining witnesses for the claim.
Examining the witnesses, already section 14 is already there, my lord. That gives the power to the tribunal, your lordship, section 14.
No, procedural, that's the procedural part.
Your lordship, we kindly say section 14(8), my lord. 14 clause 8. The tribunal has power. If there is no power, then civil court has jurisdiction to examine the genuineness of the will because probate is not required in that area. Your lordship, may kindly say section 14.
Let's come to page 30. Okay, before we do that, come to page 30 of the impugned order.
Impugned order, your lordship.
Both the parties to the proceedings. Just argue, just read that part.
Yes, my lord, they attended the relief. Both the parties to the proceeding argued and insisted that this tribunal should give a finding on the genuineness of the will. The petitioner of TC number 16/2013 means son have controverted the genuineness of the will on the ground that Dubraj was ill and not in a fit state of mind in the year 1995 to execute the will. And the will is appeal have been executed on 13/7/95. Dubraj died few months thereafter. Prior to that, he was completely bedridden, ill and suffering from various old ailments. So Birendra Patel and Sudhir Patel means a present appellant, my lord, by impersonation have managed to obtain a will purported to have been executed by the testator. Then, your lordship, this is a factual question is to be answered with regard to the genuineness of this will.
Yes, carry on.
Your lordship. And this tribunal being created for a specific purpose for determining the amount and to look into the apportionment of the amount cannot go into the other question like the right title interest of the party over a particular property acquired by the central government. The counsel for both the case argued that section 14(8) of the act gives the tribunal of the powers of a civil court, and when the power of the civil court has vested under section 26 of the said act, this is the appropriate forum to decide the genuineness of the will and consequently decide the interest of the parties. For better understanding, the provision of section 14 of the act is quoted below. The tribunal in the proceeding before it shall have all the powers which the civil court has while trying a suit under the Code of Civil Procedure 1908 in respect of the following matter, namely summoning and enforcing the attendance of any person and examining him on oath, requiring the discovery and production of any document, reception of evidence on affidavit, requisitioning any public record from any court or office, and issuing commission for examination of a witness. A plain reading of the said provision leads to a conclusion that the tribunal has to exercise the power of the civil court to go ahead with the hearing of the dispute, and this is only a procedural power allowed to the tribunal when the tribunal has been constituted with a limited scope and section 26 has ousted the jurisdiction of the court. That is the finding.
Well, that's all. Yeah. Not for others. Yes, madam. Carry on.
Your Lordship. It is held that to determine the genuineness of the will and consequently to determine the right title interest of the parties on the property, keeping in view the recitals of the will is not within the power of this tribunal, which can only be decided by an appropriate civil court having jurisdiction. The same view has been taken by the Honorable High Court of Orissa in the case of Nakula Sahu and others, Srimati Draupadi Singh and others, WPC number so and so, decided on 22nd December 2015, wherein the Honorable High Court of Orissa have held in the following manner. On a plain reading of section 26 of the Act, it would show that a civil court's jurisdiction to entertain the suit or other proceeding stands specifically excluded in relation to any question referred to in section 14 of the Act. It is evident from the language employed that the exclusion is not absolute or all pervasive. Prayer with regard to 1 and 2 quoted in paragraph 2 supra made in the suit and issue with regard to right title interest of the plaintiffs over the suit land and declaration of the sale deed executed by dependent number 1 in favor of dependent number 2 and 4 as void are to be tried by the civil court since the same are not covered under section 14 of the Act. The tribunal has not been conferred with any jurisdiction to decide the said issue. That in view of the above observation of the Honorable High Court and a conjunctive reading of section 14 and section 26 of Coal Bearing Act 1957, it is held that the will conferring an absolute interest over the acquired property cannot be taken into consideration by this tribunal unless there is a clear finding to that effect by the appropriate civil court. Since the will diverts the natural way of succession, the party seeking benefit from the will has to move the civil court and take a declaration to that effect. Till then, the interest of all legal heirs and successor of Dubraj over the property under Khata number
Yes,
2.
so you make your submission now, madam. We'll continue after lunch. We'll continue after lunch.
58 of 97, I have filed that further short note. With regard to the maintainability of that.
Right. Yes, madam.
My lord, my respectful submission before your lordship would be, after reading the relevant para of this judgment, that the section 26 of the Coal Bearing Act that clearly bars the jurisdiction of civil court.
No, that is as far as compensation amounts are concerned.
That your lordship, that has not been clarified. May I read again that section 26, my lord?
Yes.
I may be permitted to read. Save as otherwise expressly provided in this act, no civil court shall have jurisdiction in respect of any matter which the central government or the competent authority or any other person is impaired by or under this act to determine.
Correct. So this act does not empower any authority, including central government, to determine the genuineness of a will.
Yeah.
So section 26 will not prevent the civil court from examining the genuineness of the will.
Well, that is section 14 is also the
14 is about the procedure, madam. 14 is what procedure should the tribunal follow. See, the tribunal should be able to take statements on oath, correct? Summon people to appear before it. So for all that, the civil court's powers have been given to the tribunal.
That is one thing, madam. That regarding genuineness of will, that will, it is admitted that has been executed in the year 95. Since 95, though nobody had challenged that genuineness.
They were not aware of it. When you came to this tribunal, you suddenly produced this will and said, this will permits me to get the entire compensation.
But by virtue of that will, ROR have been published since 2003. Since 2003, ROR have been published.
No.
That has not been challenged by anybody.
There is no estoppel as far as ROR is concerned, madam. You know, ROR does not confer title at all.
No.
The settled law is that entries in an ROR do not confer title.
So another, the real difficulties, impediment is that since 95, land has already been acquired. So 93. So
no, I wanted to ask you, what is this interim order dated 21st September? Where do you find that order?
Your lordship, that is that by virtue of will, that property is divided into two parts.
Where is that order? Where do you find that order?
No, that is in impin order itself. It is clarified. Impin order, your lordship, in order, ordering portion, page 37. Your lordship. Ordering person, page 37, second para, kindly see, my lord. The amount of compensation deposited with ADM R&R MCL, Basundhara Gazipati area for the land acquired from Khata number 29 of Mauja so and so shall be divided among so and so LRs of A, allowing 1/6 to each. Since some amount of compensation has been released in favor of Birendra Patel, that is appellant number 1, my lord, for land measuring 3 acre 52 decimal, the parties are at liberty to realize the same from Birendra Patel through the process of law.
No, I'm asking you some other question.
My lord.
If you come to the interim order dated 3rd October 2016.
My lord.
In MFA 2 of 2016 and the interim order dated 3rd October 2016 in MFA 1 of 2016.
Your lordship. Then the interim order was there, my lord.
No, you read that interim order. That interim order says,
my lord,
the interim arrangement made on 21st September 2015,
my lord,
CMP 738. Where is that order?
My lord. That is CMP, that order passed in CMP, that arrangement was made, that was order, that compensation amount was kept in fixed deposit with the ADM.
Where do you get that order, madam? Where is that order? We haven't seen that order.
That was, my lord, that was produced at the time of admission, my lord. So
Where is it?
this is with me, my lord, but that is produced, already produced, my lord. So thereafter, my lord, that interim order is continuing. That may be produced, but MCL, my lord, advocate is there. So that he is also well aware of that.
Which advocate is there? You are aware of that order?
Order
21st September order.
at that time. Thereafter, the notice was issued. Records have come. CMP records have come before your lordship. Your lordship may kindly see.
Where is the CMP record?
Records are attached.
CMP 738 by 2014.
But that order is not in this. Ah, there is 1/7/2014. So
Yeah.
wrongly mentioned. No, it's here. 21st September. Ah.
That order date is 21/9/2015, your lordship.
Right. All right. We'll quote this order.
Last
All right.
part.
Anything else, madam?
Oh, my lord, already 25 years already passed. If your lordship held that I should be
Quote this.
approached civil court, then your lordship, that is subject to the decision of this
You
tribunal.
be content. Don't fight with your sisters. Be content with 1/6. That's the only way. All right. All right. Both appeals are dismissed. Detailed order will be passed.
Your lordship, only observation, my lord, my submission, if these orders allowed to stand, my lord, say then civil court jurisdiction, if that on one hand tribunal said that civil court jurisdiction is there, on other hand,
We'll interpret, we'll clarify all that. We'll talk. We'll say about what the scope and ambit of section 26 is. Yes.
With that observation,
My appearance may be noted.
Yeah, the order will discuss 14(2), 26, all of that.
Lord, my appearance may be noted. I am appearing from OP number 8, my lord.
All right. All right.
And in second case, OP number 10.
All right. All right.
only, my lord, that may be disposed of. But if that will be dismissed, then it will be.
When we are affirming an order, we dismiss.
Disposed of,
All right.
only disposed.
All right. All right.
Supplemental list, item number 12.
None appears. This was not discussion.
Supplemental list, item number 13.
13, my lord. As per note, requisite not filed open number 3. I have filed already today. I have already filed my note.
That's all right. Tell us what the matter is.
My lord.
Tell us what the matter is, sir.
Here, my lord, may I just come in?
Declare rule 4(1) of the placement rule to be illegal. What is placement rule? Placement of lecturers of aided college into the lecturer scale on completion of 8 years of service from the approved date of initial joining. The reader state scale after 10 years of deceased lecturer.
Lord, the same rule has been challenged by another petitioner. In that writ petition, your lordship has adjourned it to 22nd of August.
All right. It's a list on 22nd August 2022. In the meanwhile, fresh notice be issued to opposite party number 3 and 4. Returnable for the above date. The requisite already filed for opposite party number 4 be utilized as far as service to opposite party number 4 is concerned. All right.
Supplementary list, item number 14.
No instruction, madam.
No instruction disposed of.
Supplementary list, item number 15.
None appears. Dismissal not possible.
Supplementary list, item number 16.
None appears. Dismissal.
Supplementary list, item number 17.
May I please, your lord? My lord, this is PIL matter, my lord.
Yes.
Village pond has been partly manner encroached, and the villagers have filed a representation at annex 1 before the collector, my lord. Lords may direct the collector to look into the matter.
Where have you made the encroaches parties? Make them parties, sir. You also have to name them in the representation.
My lord, I shall amend.
Don't amend. You file a fresh representation. Counsel to the petitioner seeks leave to withdraw the present petition with liberty to file a fresh representation in the first instance before the authorities, naming the encroachers. And after following up on such representation, to seek appropriate remedies in accordance with law.
Oblige.
Disposed of is withdrawn with liberty is paid for.
Oblige.
Supplementary list item number 18.
These are all infractions.
OA transfer cases.
Transfer cases, all infractions.
Supplementary list item number 19.
None appears. Dismissal non-constitutional.
Supplementary list item number 20.
My lord, item number 20, defects shall be removed within 1 week, my lord.
1 month?
1 week, my lord.
1 week.
Yes, my lord.
Counsel for the petitioner states defects will be removed within 1 week. List thereafter.
Obliged.
Supplementary list item number 21.
Yes, one minute. Annexure 2 is pending before the OP number, Miller. 2 Miller.
Annexure?
Annexure 2 Miller. 1 series. For page, running page 14 Miller.
Your lordship usually directing the local locayuct to consider these applications. Here, my lord, the allegation
it will be open to the petitioners to approach the loci in respect of the grievance made in the present petition by filing an appropriate proceedings in accordance with law. The petition is disposed of.
Supplementary list item 22.
None appears. Dismissal non-prosecution.
Supplementary list item number 23.
23, my lord. The matter is related to deduct the money of the old GPF scheme. My lord. An identical matter, my lord.
The copy has not been served. Copy has not been served.
Please serve a copy, sir.
My lord. Identical matter posted for hearing 19th for 2021. 19th for my lord. 19th for.
So we list on 19th April. In the meanwhile, copy of the petition is served on opposite parties.
Man, which number, my lord? 6725 of 2021.
6725 of 2021.
21, my
lord.
Supplementary list item 24.
24, my lord, 1 week time for removal of defect, my lord. 1 week time for removal of defect, my lord.
Counsel to the petitioner states that he'll remove defects within 1 week. List thereafter.
Supplementary list item 25.
25, my lord, I pray for 1 week time to remove the defects.
Same order in this 25.
Supplementary list item 26.
May I please, your lordship? Here is a case of the petitioner that the canal embankment, which was adjacent to state highway and national highway, which has been encroached by the opposite party number.
All right. Petitioner's representation dated 13/12/2021 be examined by the Collector Khurda.
My lord.
And after issuing notice to the petitioner as well as opposite party numbers.
My lord, may kindly direct to the Tahsildar Bhubaneswar. Annexure 4, my lord.
Okay, Tahsildar Bhubaneswar. And after issuing notice to the petitioners as well as opposite parties 6/2/23. And after giving them a hearing, a reasoned order should be passed not later than 1st August 2022 and be made available to the parties not later than 8th August 2022. The court clarifies it has not expressed any view on the matter.
Supplementary list item 27.
I may be permitted to appear to virtual mode. May I please, your lordship? So far, the defect number 9 is concerned, my lord, it has to be ignored because in the cost title itself, I mentioned the provisions of law.
All right.
So, in this petition, I challenged the summons dated 1/12/2021 issued by the opposite party number 1. During pendency of the appeal before the CIT appeal. My lord, what has happened in this case? The petitioner has been assessed. If your lordship will come to annexure number 2 at page 18. Petitioner initially assessed. Where the for the year for the financial year 2000-2002, where the learned assessing officer after considering the survey, has demanded 10,08,511. The assessment order has been challenged before the CIT appeal. The next annexure at annexure number 3, the lauded CIT appeal. Without going into the merit of the case, has disposed of the appeal as for non-prosecution.
All right.
Then against that order, we have challenged the same before the learned IT-80 Cuttack bench. The learned IT-80 Cuttack bench has set aside that CIT appeal order with a direction to give an sufficient opportunity of hearing to the petitioner.
Right.
At annexure 4, page 25, the order in the IT-80.
Right.
So the matter stood thus. The London TR tax recovery officer, opposite party number 1, has issued several letters starting from annexure 5, then 7, then 9 for payment of the demanded dues and interest.
Your matter is still pending with the CITA.
That's why I am before your law.
For 15 years.
My law.
For 13 years. What is this? How can such a appeal be pending in CITA for 14 years and 15 years?
Not,
very strange.
I will take instance. So far as demand is concerned, this so far part of the appeal is he is saying that appeal is not a takeoff.
Yeah.
Tribunal has rejected the appeal because the appellate authority passed dismissed the appeal without question.
Correct. How can you have a demand, sir?
No, demand is something different. He has to produce the stay order because they are these
if
are
the appeal itself is not taken up, where will you produce stay order from?
No, appeal is, but see, so far as the first appeal, he has to deport some amount. Then after the tribunal, but thereafter, I come back with some judgment. Pendency of the appeal, there's a bar for the TRO to proceed further.
Correct.
TRO proceed not a bar during pendency appeal to proceed further. There is no bar.
No bar. Okay.
So therefore, my lord, the TRO is rightly, my lord, issued this notice in spite of several notices lordships he has enclosed.
No. If he files an application before the CITA for stay of the TRO notice, will that be entertained?
Yes, that he has to file a petition for expeditious hearing the appeal. In addition to that, he may file a petition before stay.
What I humbly pray your lordship, because the matter is pending since last 13 years before the CITA. If your lordship will give a direction to the CITA I'll appear, I am undertaken to appear on the date.
But you also ask for, we'll permit you to seek a stay of the TRO's.
Yes. I'll file an application for the.
Yes. All right. Counts for the applicant is permitted, petitioner is permitted to apply to the CIT bracket A, before whom the appeal on remand from the ITAT is pending, seeking stay of the impugned summons dated 1st December 2021, issued by the tax recovery officer bracket TRO. A further direction is issued to the CITA to expeditiously to expedite the disposal of the pending appeal of the petitioner, and in any event dispose it of in accordance with law on or before 2nd September 2022. The appeal will be listed before the CITA for directions on 25th April 2022.
What I pray, my lord, till that time, till that date, till disposal of my petition, which I will be filing before the CITA, the summon recovery procedure.
All right, till that date, yeah. Till such time the CITA passes an appropriate order on the application for interim relief, the impugned notice of the TRO will not be proceeded with.
He has to cooperate with the proceeding, Lord, because your lordship, that one line maybe has to.
You can say that to the CITA. It's all right. Yes.
Much
obliged. All matters. Yes.
Supplemental list for admission, item number 28.
This regarding encroachment of a particular piece of land by a sitting MLA in Bhubaneswar, my lord. And this PIL was filed
What is the
for
present
removal of
status? We
encroachment.
wanted to know the present status.
Yes, my lord, I have filed the counter, my lord. My lord, they have already initiated eviction proceeding against the opposite party number 8, and out of total acre 4.226 decimals, my lord, only 3.56 decimal has already been evicted, and here all the boundary wall has already been constructed over that particular land. Balance, so far as balance
Where is
portion,
the affidavit? 1 minute. Where is the affidavit?
it was filed yesterday. Right? It amro option can
Para 7 million. They removed a part of it and remained still
no
with the encroacher.
My lord, out of 4.226 total area, my lord.
Para 7.
Your lordship may come to para 6, my lord, page 4.
Yes.
Lordship, that after disposal of OPP case, eviction program was conducted through the Central Enforcement Monitoring Committee during the year 2014-15. The photographs taken at the time of eviction are annexed here for kind perusal. After demolition of the unauthorized structure covering area of acre 3.56 decimal, boundary wall was constructed to protect the government land. A photograph of the area protected after demolition of the encroachment is enclosed here. The field verification was conducted by the officials of J Department to ascertain the position of area measuring acre 4.226 decimal covered under in OPP case number 41 of 2003. The field inquiry report dated 2/4/2022 indicates that area measuring acre 3.56 decimal has been protected by compound wall after eviction. The balance area measuring acre 0.660 decimal is under the unauthorized occupation of Kasinath Malik by construction of asbestos house, RCC house and garden. And my lord, the next part your lordship see the in respect of area measuring acre 0.660 decimal under unauthorized occupation, appropriate action will be taken through the central enforcement.
What is that will be taken?
My
When
lord,
will it
in
be
fact,
taken?
my lord, I was also asking them. They told that due to the election, my lord, they
That's
couldn't.
all over
But they have actually assured me that they will take the immediate action within a period of 2 months. My lord.
All right. The affidavit dated 2nd April 2022 of the Executive Magistrate Bhubaneswar has been produced. It is stated therein that of the total area of AC 4.226 decimal covered in OPP case number 41 of 2003, an area measuring AC 3.566 decimal has been protected, has been recovered and has been has been relieved of the encroachment and is now protected by a compound wall.
Yes.
As regards the balance area of AC 0.660 decimal, which continues to be under the unauthorized occupation of opposite party number 8 by constructing an asbestos house, RCC house and garden. It is stated in the affidavit that open quotation appropriate action will be taken through the Central Enforcement Monitoring Committee (CMC) for eviction following due process of law. Paragraph. It is directed that the action be initiated as regards the area measuring AC 0.660 decimal in a time-bound manner and be completed by the CEMC not later than 2 months from today. That is in any event not later than June 13th, 2022. A compliance affidavit be placed on record on the next date.
Great.
List on 20th June, opening day.
Supplementary list item number 29.
In compliance of order dated June 10th of February 2022, I have filed a compliance affidavit that is available at flag B. Flag B is the compliance affidavit. Paragraph.
Yes.
Paragraph 3, internal page 2.
Yes.
There we have stated that the lady that is Mounavati Kavi is now residing at Mission Asra Jahala under treatment of different doctors. And
It's an old affidavit, 2013. So recent affidavit you're referring to?
yes, recently they have.
What's the date?
This was dated
31/3.
Paragraph 3. Your
No,
Lordship.
this is, we have only a 2nd May 2013 affidavit.
No, it was filed on 31/3.
31/3?
Yes, ma'am.
No, which year?
22.
No, we haven't got a copy. Copy of the affidavit dated 31st March 2022. You have another copy?
Yes, ma'am. Only one extra copy. For sign, ma'am. Sign. Last page color photo ଅଛି ତ? Black and white. Black and white photo ଟା ରଖିଦେଇଛନ୍ତି। ମୁଁ କପିଟା ବି ଦେଇଦେଉଛି। ସେଟା ବି ନେଇଯାଅ। Since in the extra copy the photograph is black and white, so I am passing my copy colored photo. Paragraph 3 of the affidavit.
Yeah. Manavati Kavi's health is good. All right. An affidavit dated 31st March 2022 has been filed by the collector. No, by the Additional District Social Welfare Officer Baleshwar on 31st March 2022. So it is stated therein that the District Social Welfare Officer Baleshwar as well as the Child Development Project Officer Bahanaga contact the family members of Srimati Maunabati Kabi residing at the Mission Ashram Janla in the district of Khurda. Ashram, no? Mission Ashram Janla in the district of Khurda since 2013. Paragraph. The family members of Srimati Kabi just say on a personal interaction with Srimati Kabi, it was found that her health condition is good. She is under psychiatric medication under the direct supervision of physicians. At this stage, therefore, no further directions need be issued. The petition is disposed of.
Supplementary list item number 30.
May I please? The petition was appointed as a peon. Lordship can have a glance to Annexure 2, page 11. He was appointed as a peon and posted at the Office of Registered Civil Code, Navrampur. After 2 years, under Annexure 3, page 12, a SOCUS was issued directing him to submit reply within 3 days why disciplinary action shall not be initiated. Immediately thereafter, on 24th March 2014, a memorandum of charges were framed and DP was initiated. Lordship can have a glance to page 14. The two charges, one is Sri A. Tripati Rao with a board. My name is A. Tripati. In some certificate, my name counts as A. Tripati Dora, and in some school education certificates, but in ROR and in Aadhaar card, voter card, my name shows that A. Tripati Dora. So I got appointment as A. Tripati Rao. Since my name found place as A. Tripati Dora in education certificates, they directed me to why you have misrepresented and committed a fraud. That is why DP was initiated. Your Lordship kindly have a glance to thereafter. article of charges framed. And the counter, they have stated that the petition was allowed to sit in the recruitment test and again at the time of his joining candidate peon in 3/12/2012 for the fault upon Sri Sanjay Kumar Raut, court manager, he could not be pointed out and the petitioner succeeded and in the examination and appointed as a peon. Now what the district judge, director, and CGM as an inquiry officer. The inquiry officer submitted a report in my favor in 2014. But since 2014, the DP is continuing. Neither I have been suspended, nor I have been terminated, nor allowed to join my. Your Lordship, kindly have a glance to the page 37, annexure 11, which is my rejoinder, the report of the inquiry officer. Annexure 11. Your Lordship may allow me to point the relevant paragraphs of the inquiry report, the findings of the inquiry report.
Are you able to open the bookmark? There's no bookmark in this. Give us a hard copy. Yes, please.
The internal page 7, space 37 is the main page, my lord. Annexure 11, that is my rejoinder affidavit, the report of the inquiry officer. First, he has dealt with charge number 2 and subsequent charge. Page 38, your Lordship, kindly see. So
the findings are clear, Mr. Mudali.
He challenging the initiation of DP itself. The DP is still continuing, madam. In the meanwhile, 8 years has been passed. Neither they allowed me to join.
Challenge, so that's why they have not passed the final order.
No. Your Lordship, kindly see. Page annexure
stay
30.
Here.
No stay.
Then.
Completed
it by now.
The entire proceeding is under challenge.
No.
Today morning.
Challenge, but if there's no stay, you should go ahead and complete it.
You Lordship, give that liberty.
What? After so many years. You have retired in the meanwhile?
No. 30 years. Today, now I am 37 years.
Oh.
Pursuant to a recruitment
so we'll give a time-bound direction then.
Yes.
Your Lordship, kindly see, just for a moment, page 44, last annexure of my rejoinder. With reference to a representation, even after the inquiry report, I submitted representation to allow me to join. What they have done, the representation in abeyance is kept in abeyance till finalization of department proceeding. Till that they have not.
Counsel for the opposite party, counsel for the petitioner refers to the inquiry report dated 31st May 2014, passed by the Chief Judicial Magistrate cum Inquiring Officer Navarangpur, in which inter alia there is an exoneration of the petitioner from the charge of producing any false certificate or resorting to impersonation. Paragraph, counsel for the petitioner states that despite the above exoneration, the inquiry against the petitioner is not concluding.
Inquiry completed.
No, the disciplinary proceedings.
Disciplinary proceedings.
The disciplinary proceedings against the petitioner is still kept pending. And even the representation dated 16 July 2018 of the petitioner has not been considered for its expedition. for its expedited conclusion is not being considered on account of the present petition paragraph. Considering that the petitioner already stands exonerated in the inquiry, a direction is issued to the concerned inquiring officer as far as the disciplinary proceedings is concerned to conclude it within a period of 4 months from today. A copy of this order be communicated forthwith to the District Judge Navrangpur for compliance. The petition is disposed of.
Supplementary list item 31.
May I please, Your Lordship? Lordship, I am in PC, Your Lordship. Lordship, the petitioner here challenges the shifting of the offices, my lord, like the Special Relief Commissioner and the Office of State Port Engineering from the Cuttack to Bhubaneswar, Your Lordship.
We're not interfering with these kind of issues, madam. This is not a PIL. The present PIL questions the shifting of the office of the Special Relief Commissioner.
Lordship, the OP has filed counter, my lord. I have to file my rejoinder, Your Lordship.
No,
Let it
no,
come
no.
next week, I will file.
Why should these are not issues which we should be concerned with at all, madam? Shifting of the office of the Special Relief Commissioner and the State Port Engineer from Cuttack to Bhubaneswar. These are not matters in which the court would like to interfere in a public interest litigation. The court therefore declines to interfere. The petition is dismissed.
Supplementary list item 32.
Kindly taken up next week. He is ill.
No. What's the matter about?
I'm not no power, my lord. I'm not the problem. Just he has given the telephone message, my lord. He is ill, my lord.
He's ill?
Yes, my lord.
Counsel, the petitioner stated to be ill. So, July.
Supplementary list item 33.
This will take some time, Mr. Monty. No, yes. We'll just take it up the end of the board.
Supplementary list item number 34.
May I please, madam? This matter relates to the retirement of a reader at 65. The petitioner, who was working as a reader cum principal in charge in an aided college, namely Hindu College, is entitled to be retired at 65, that is on June 2025. But whereas due to the retirement policy at 60 in Orissa, he has been made to retire at 60 on in June 2020, and therefore the petitioner challenges in this writ petition the virus of the Rule 19 of the Orissa Education Recruitment Rules 1974. Lordship, kindly up page 69. It says that every employee shall retire on completion of 60 years of age, and prays for that he is entitled to be retired at 65 as per the scheme of the Human Resource Development and the regulations and other provisions and other settled law. So he prays that should be considered. And Your Lordship, may I be permitted to place the scheme which was noted by Human Resources Development Department at page annexure 6. And this scheme was later on annexed as annexure 1 in the UGC regulations. Your Lordship, kind of page at page 38. My lord. This is the scheme introduced by Ministry of Human Resource Development subject scheme of revision of pay of teachers and equivalent cadets in universities and colleges following the revision of pay scales of central government. The central government employee on the recommendations of the 6th Central Pay Commission. Sir, I am directed to say that the government of India have decided, after taking into consideration the recommendations made by the University Grant Commission, based on the decisions taken at the meeting of the commission held on 7-8 October 2008, to revise the pay scales of teachers in the central universities. The revision of pay scales of teachers shall be subject to various provisions of the scheme of a revision of pay scales as contained in this letter, and regulations to be framed by the UGC in this behalf in accordance with the scheme given below. This is the view. For my purpose, for the petitioner's purpose, this superannuation pay is necessary. So, Your Lordship, kindly have a glance at para 8F at page 49. 49. This is relates about 8F relates about the age of superannuation. It has been permitted to read. You need to meet the situation arising of shortage of teachers in universities and other teaching institutions and the consequent vacant positions therein. The age of superannuation for teachers in central education institutions has already been enhanced to 65 years. So this aspect.
So yours is not a central university.
Yeah, I'm coming to that point. Later on, in this scheme itself, it has been mentioned in 8 PV. Let's see, kind of at page 52. P2B, this scheme may be extended to universities, colleges, and other higher educational institutions coming under the purview of state legislatures, provided state governments wish to adopt and implement the scheme subject to the following terms and conditions. My lord, before that, may I take your lordships to kind attention to the P, that is at page 51, towards the last para. This scheme shall be applicable to teachers and other equivalent cadres of library and physical education in all the central institutions and colleges thereunder, and the institutions deemed to be universities whose maintenance expenditure is made by the UGC. The implementation of the revised scale shall be subject to the acceptance of all the conditions. I am emphasizing, my lord, all the conditions mentioned in the letter as of the regulations to be framed by the UGC in this behalf. Universities implementing this scheme shall be advised by the UGC to amend the relevant statutes and ordinances in line with UGC regulations within 3 months from the date of issue of this letter. My lord. So another is answered page 52. It is G. G says payment of central assistance for implementing this scheme is also subject to the condition that the entire scheme of revision of pay scales, together with all the conditions to be laid down by the UGC by regulations and other guidelines, shall be implemented by the state governments and universities and colleges coming under their jurisdiction as a composite scheme. I emphasize this word, particular 2 words, composite scheme. My entire endeavor is, my submission is that this scheme demands that this scheme shall be implemented as a composite scheme and not one another. And this, my lord, thereafter, what happens? The lordship kindly have a glance at their counter, my lord. What they have done. In my petition, I have annexed this scheme, and they have what they have told, my lord. At page 85, my lord. In their counter filed by opposite party 1 and 2, that is the principal secretary and the director. May I permitted to read para 9, that the petitioner is read application at para 6 to 8 has heavily relied upon the government of India in the Ministry of HRD notification dated 31/12/2008, wherein at clause 8 PV, it was stated that the scheme may be extended to the universities, colleges, and other higher education institutions coming under the purview of the state legislatures, provided the state government wishes to adopt and implement the scheme. However, This is important, my lord. On the date the state government of Orissa, in exercise of its conscious decision, has never exercised its wish to accept such scheme and to impose any such financial burden on the state government. Here, Your Lordship, this is the false affirmation made in this counter affidavit, and I am showing how it is false. Your Lordship, kindly have a glance at my rejoinder, annexure 12 at page 184, running page is 184. Actually, the state government has implemented the scheme, but not completely, not as a composite scheme. And here making false affirmation that we have not implemented the scheme. 184, man. My lord, this is the letter issued by the government of Orissa Department of Higher Education, and the date is 14th December 2009. And this letter, Your Lordship, kindly have a glance at para 3, towards last page. The para 2 first may I permit you. The government of India, Ministry of Human Resources Development, Department of Higher Education, after considering the various recommendations of the UGC on a revision of pay scales of the university and college teachers, communicated their decision to UGC in their letter such and such dated 31st December 2008. The scheme that has earlier mentioned before Your Lordship, my lord, UGC has communicated their decision to state governments in their letter such and such dated 20th February 2009 and requested to implement the scheme in state in a time-bound manner. My lord, kindly have the glance. The question of a revision of pay scales for university and college teachers on the basis of recommendations of Government of India and the UGC was under consideration of governments for some time past. After careful consideration, the state government have been pleased to implement the scheme of revision of pay scales for university and college teachers with the following terms and conditions. And Your Lordship, can have next page 185. Other conditions, as soon as the regulations laying down other conditions are received from UGC, the same may be considered by the state government. So, my lord, the scheme was enunciated on 31st 12/2008, and it was this scheme, the very scheme was implemented by the state government on 14th December 2009, and it was also came to the Gazette notification on February 3rd February 2010. So, as per the scheme, that the scheme should be implemented by the state government by as a composite scheme, but it has not been done so. Had it been done so, then the regulations, the 1974 Act would have been amended by the state government. That is, Rule 19 should have been amended, and the editorial lecturers should have been allowed to retire at 65, not 60. This is the argument. And in their when in their counter, they have also given another. They have cited a decision, Jagdish Prasad Verma's statement decision, and in that decision, they have said that the petitioner is not entitled to be retired at 65 as per the decisions. May I permitted to cite the decisions? My decision, that is 2013 8 SCC 633 page. First para 9. This judgment also describes about the this scheme, very scheme. Para 9. Para 9 is at page 641. May I permitted to read? The most important development at the relevant time, however, was the issuance of a letter by the central government in the Ministry of Human Resource Development, Department of Higher Education, to the Secretary University Grant Commission on 31st/12/2008 regarding a scheme of a revision of pay of teachers and other equivalent cadres in all the central university and colleges and deemed universities. Following the revision of universities and colleges and deemed universities, following the revision of pay scales of the central government employees on the recommendations of the 6th Central Pay Commission, subject to all the conditions mentioned in the letter and regulations, the state governments were given an option to adopt in its composite form. Your Lordship, I pray that kindly have a glance at page 78. Sorry, 663 page, paragraph 78. The concluding remarks or the directions of this judgment of the Supreme Court. We are then faced with the situation where a composite scheme has been framed by UGC, where the Commission agreed to bear 80% of the expenses incurred by the state if such scheme was to be accepted, subject to the condition that the remaining 20% of the expenses would be made by the state and that on and from 1/4/2010. The state government would take over the entire burden and would also have enhanced the age of superannuation of teachers and other staff from 62 to 65 years. There being no compulsion to accept and/or adopt the said scheme, the states are free to decide as to whether the scheme would be adopted by them or not. In our view, there can be no automatic application of the recommendations made by the Commission without any conscious decision being taken by the state in this regard. I am putting but here our Orissa is different because Orissa has adopted the scheme, and so this in their counter they have only emphasized on this paragraph. But here my humble submission is that the 78 paragraph is not applicable to the petitioner's case. Rather, the petitioner's case is squarely covered by the paragraph 79. Your Lordship, I may be permitted to read that. However, within this class of institutions, there is a separate group where the state governments themselves have taken a decisions to adopt the scheme. This is my submission is that as I have shown Your Lordship at Annex 12, since the state has adopted the scheme, so in such cases, the consequences envisaged in the scheme itself would automatically follow. So this is the my humble submission is that this paragraph 7, the petitioner's case is covered by the paragraph 79, since the state government has adopted the scheme. But just one line. But in their counter affidavit, they have made false argument. We have not adopted the scheme, and in their reply to rejoinder affidavit also, they have also said or made the argument same thing. Your Lordship, and have a glance at page. Page 216, my lord. Running page 216. It is para 7b. Just last 4 lines I am reading. Therefore, the applicability of the said judgment of the petitioner has heavily relied upon the recommendations of the UGC, but such recommendation is not binding upon the concerned state, provided the state wishes to adopt and implement the scheme. So, but here, whereas in case of state of Orissa, in exercise of its conscious decision, has not wished to accept such scheme. This is the blatant lies, the false argument made before this honorable court. The thing, neither the government colleges, regular teachers, or nor the non-government colleges. And furthermore, I have the document to show, Your Lordship, in my rejoinder, that they have not only implemented the scheme, they have also adopted and implemented the UGC regulations. Your Lordship, kindly have a glance at page Annex 14 at page Annex 14. 115, my lord. Sorry, sir. 115, internal page. Uh, 115, 206, running page is 206. In inviting a reference to this department resolution such and such, I am direct to say that the designations of lecturers and readers receiving UGC scale of pay has not yet been implemented in non-government aided colleges. Therefore, the government have been pleased to intimate you to instruct all the principals of non-government aided colleges to redesignate the lecturers and readers receiving UGC scale of pay as per this department resolution such and such. And here also UGC regulation 2010 and 13 has been categorically mentioned in at page 207. Your Lordship, kindly have a glance at 207, promotion to second para. Promotion to associate professor grade shall be subject to the fulfillment of minimum academic performance index score involving research publications, research projects, research guidance, attending national, international conferences, aids which shall be calculated as per UGC regulations 2010 and 2013 respectively as amended from time to time. So my humble submission is that the state government in Orissa has implemented the scheme and as well as the UGC regulation of 2010. But by making the false averment before this honorable on two occasions, that in counter affidavit and also in reply to reserve affidavit they have made, they have not implemented the scheme.
Much allegations have been made, Your Lordship. May kind down to page 49. The part of the scheme, page 49, bottom. Age of superannuation. In order to meet the situation arising out of shortage of teachers in universities and other teaching institutions and the consequent vacant position therein, the age of superannuation of teachers in central educational institution has already been enhanced to 65 years by the Department of Higher Education letter number so for those involved in classroom teaching in order to attract eligible person to the teaching career and to retain teachers in service for a longer period. Now, my lord, may kind down to page 52. There they prescribed for enhancement of the age up to 65 years. Page 52, clause B, Roman B. The scheme may be extended to universities, colleges, and other higher educational institutions coming under the purview of the state legislatures, provided state governments wish to adopt and implement the scheme subject to the following terms. So liberty was granted to the states whether to accept in toto or in piecemeal manner. Now, Your Lordship, may kind down to Annexure 12, which has been annexed to the rejoinder. He is placing a part and not placing the entire document. Annexure 12 to the rejoinder, Your Lordship, may kindly turn to when they have accepted subject to certain paragraph 3. The internal page 93 of the rejoinder, Annexure 12. May I please, ma'am? Annexure 12, internal page 93. Paragraph 3 towards bottom. The question of revision of pay scales for university and college teachers on the basis of recommendations of Government of India and UGC was under consideration of government for some time past. After careful consideration, the state government have been pleased to implement the scheme of revision of pay scales for university and college teachers with the following terms and conditions. So that is important. With the following terms and conditions. Now, my lord, may kind turn to same annexure, page 98. Page 98, paragraph 13. Age of superannuation. Keeping in view the age of superannuation of state government employees, the age of superannuation in case of college teachers shall be 58 years. However, for the university teachers and non-government aided college teachers, the superannuation age shall continue to be 60 years. So government has taken a conscious decision that the retirement age will be 60 years. And this notification which he relied upon, he has never challenged this notification.
May I be pardoned to Yes, but
Let him speak for at least 5 minutes, sir.
He has accepted this annexure, this resolution and never questioned the same. Now, my lord, kind note to my counter affidavit. Running page 85.
Yes, sir.
He has placed paragraph 9, I am placing paragraph 10. That it is humbly submitted that the sole question of law before this honorable forum is to decide as to whether the scales of pay and age of superannuation as provided in the UGC regulation 2010 are binding on the state government to implement the same for the universities, college and higher educational institutions, both government and non-government aided, coming under the purview of state legislation and maintained by state government. The above issue was answered long back in 2013 by a 3-judge bench of the Honorable Apex Court in the case of Jagdish Prasad Sharma. Then we have quoted paragraph 78 of the Jagdish Prasad Sharma. Now next page, paragraph 11. That it is needful to mention here that in the aforementioned civil appeal number so Jagdish Prasad Sharma versus State of Bihar and batch matter, the private party teachers, namely Ashutosh Samantra and others of Orissa University of Agriculture and Technology have filed SLP against the impugned order dated 12/4,
which he was referring to.
Yes, Jagdish Prasad. In those batch of cases, one writ petition also, SLP was also preferred from the state of Orissa, where the prayer was rejected for enhancement of the age of superannuation. There, that we have stated only. The private party teachers, namely Ashutosh Samantra and others of Orissa University of Agriculture and Technology, had filed SLP against the order dated 12/4/2012 in WPC number so and WPC number so of the division bench of Honorable High Court of Odisha on the issue of enhancement of age of superannuation of the teacher from 60 years to 65 years, which was converted to civil appeal number so and was subsequently clubbed together with the leading case in the batch matter Jagdish Prasad Sharma. Consequently, with the above observation finding, the Honorable Court dismissed such civil appeals filed by the private party teachers, making observation that both the state authorities and central authorities will be at liberty to work out the remedies in accordance with law. So, in accordance with the liberty granted by the UGC, we have, whatever possible, we have accepted that. And so far as age of superannuation, that we have limited to 60 years only, and we have never taken any decision. So, there is no false averment. And one more thing, he has relied upon the judgment of R.S. Swan of the Honorable Apex Court. Well, that judgment we have distinguished that that judgment has no application, because in the state of Maharashtra, there was a discrimination. They enhanced the age of superannuation to the government-aided colleges and the teachers of the government-aided colleges, but whereas that was not allowed to the private colleges teachers. In that situation, Honorable Apex, but here, so far as state of Odisha is concerned, so age of superannuation is 60 for both colleges, both types of colleges.
That's it.
Yes.
My learned friend has submitted before Lordship that up to possible extent they have implemented the scheme, but that is not the scheme. Again, I am reading, my lord, page 52. Your lordship, for sake of at the cost of reiteration, they cannot pick and choose in case of implementing the scheme. They will not implement the scheme. Will never, as the Tamil Nadu has done. They have never implemented the scheme. But here, the question is that if the state government wishes or chooses to implement the scheme, then the state should implement the scheme as a composite scheme. It has been, your lordship, may I, page 52, I'm reading G again, my lord. Payment of central assistance for implementing this scheme is also subject to the condition that the entire scheme of revision of pay scales, together with all the conditions to be laid down by the UGC by OAF regulations and other guidelines, shall be implemented by state governments and universities and colleges coming under the jurisdiction as a composite scheme. This is the gist of my lord. So, if they have not chosen to or wished to implement the scheme, it would have been a different matter. But as a composite scheme, they have to implement, and they have shown that. We have, in our discretion, we have made that the retirement age is 60. They cannot do so. My humble submission is that they cannot do so. They have to change the 1974 rules. Rule 19 of the 1974 rules says that every employee shall retire at 60. because this they have asked the scheme this 8P says that if you wish to, this is the direction to the states that if a particular state wishes to implement the scheme, then it should implement the scheme completely, fully, and as a complete scheme, not partially. That is that they have done. This is the thing. And as regards the RS1, particularly in the year 2019, it was not Maharashtra, it was Madhya Pradesh. Dr. R.S. Sohane was a lecturer in Madhya Pradesh, and I am just giving citing some portions, Your Lordship. Kindly have page 20, my lord. 20. This is the judgment, Dr. R.S. Sohane, Supreme Court judgment. It is a they are of the opinion that since it is a two-judge bench judgment, so it is not applicable. I will come to this aspect. And particularly, kindly have a glance at para 1 or para 21. My lord. This issue, clearly it has been mentioned, the issue that arises in the above appeals is regarding the entitlement of teachers working in private educational institutions in the state of Madhya Pradesh to the benefit of enhanced age of superannuation of 65 years. And this judgment has also, you know, so you kindly have a glance at page 23, my lord. This judgment also mentions about this scheme. A scheme for revision of paid teachers and equivalent cadres in universities and colleges was introduced on 31/12/2020 by the Ministry of Human Resource Development, Department of Higher Education, Government of India scheme following the revision of pay scales of the central government employees. The 2000 scheme included the enhancement of age of the superannuation teachers engaged in classroom teaching from 60 to 65 years on the recommendation of the 6th Central Pay Commission. The government of Madhya Pradesh has accepted the recommendations contained in the 2000 scheme on 16/4/2010. What happens in Madhya Pradesh is that they have allowed the retirement age as 62 years for both the non-government and government colleges. But this Dr. R.S. Sohane belongs to the, was a lecturer in a non-government college. So the Madhya Pradesh government has made the retirement of the government college lecturers at 65, but they retained at 65 for the non-government colleges. So the matter, the issue was there. And also, what about the role of the government? UGC regulations, it has been mentioned in para 4 minor. The University Grants Commission regulations on minimum qualifications for appointment of teachers or the recording staff in universities and colleges and measures for the maintenance of standards in higher education 2010 were framed by the UGC and exercised its powers conferred by section 26(1)(d)(e) of the University Grants Commission 1956 UGC Act. The appendix to the said regulations contains the conditions of service of teachers, including the age of superannuation, which was fixed at 65 years. My humble submission is that this appendix that was annexed into the UGC regulations 2010 was nothing but the scheme adopted by the Human Resource Department, Human Resource Development Department on 31/12/2008. This was in verbatim. They have adopted. They have annexed as the only appendix. So this is the view, and what is the judgment part, my lord? Page 37, my lord. For the aforementioned reasons, we set aside the judgment of the full bench of High Court and the consequential judgments of the division bench of the High Court and direct the government of Madhya Pradesh to pay salaries to the teachers in private colleges who are working and also those who are workers till they attain the age of superannuation of 65 years. So here there is a similarity between Madhya Pradesh and Orissa. In Madhya Pradesh, they have implemented the scheme. In Orissa, also they have implemented the scheme. In Madhya Pradesh, before this judgment, the Madhya Pradesh only they have they have only allowed the government college lecturers at 65, but private colleges they have not allowed. But here, though they have implemented the scheme of 2008, yet they have not complied implemented the scheme fully. Rather, they have retained this age of 60 till today. And in matters to the binding nature of the regulations, I admit that I have annexed this Dr. R. Sohane, and Dr. R. S. Sohane's judgment is a two-judge judgment, so it shall not be applicable. Rather, what my learned friend says, they harp on 78, and I am repeatedly saying that para 78 of the Jagdish Prasad Sharma judgment is not applicable to me, because in our case, state has implemented the scheme, though partially, but rather as the state government has applied.
He says in the Jagdish Prasad Sharma batch, there was one Orissa matter,
yes,
where the prayer was for enhancement and that was not agreed.
Because of the latches of the maybe yes, this scheme was not in where I have studiedly minutely this judgment. Nowhere it has been mentioned that this scheme was there is talk of, or there is mention about the scheme. So as the scheme was not, frankly speaking, my lord, as a junior advocate, when I filed this petition, I was not aware of this scheme, my lord. Frankly speaking, my lord. But when I became aware of the scheme, that the scheme was there and the scheme was implemented by the state government, so my humble submission is that if the scheme is implemented, so it should be as a composite scheme, fully or completely, and not partially. And in that respect, the judgment may be there, but due to the latches of the concerned advocate may not have given the scheme. So, and as regards the binding nature, your lordship, these three judgments shall not apply, shall be, or in my view, subject to the appreciation of your lordship. This three-bench judgment of Jagdish Sharma is not a correct law, as it is per incurium in nature, because of the fact that, yes, particularly, my lord, I am coming, my lord. I am citing one judgment. I have given also judgment annexed to the total judgment of Dr. Priti Srivastava's judgment. In Dr. Priti Srivastava's judgment, my lord, there is.
Sir, we are a high court. We cannot declare a judgment of the Supreme Court to be per incurium, please.
My lord, they may not be relied upon.
Yeah.
But this, our entire view is that this judgment may not be relied upon. This judgment is totally against Article 254, and I am citing, or I have taken pains to study very in detail about the first reference made by the President of India, that is Special Reference Act, and for some paragraph.
Keshav Singh.
Well,
Keshav Singh.
Not only said Delhi Act.
1912. Yeah.
1912.
Yeah.
That is
in
Delhi Act.
Delhi Laws Act.
Yes, your lordship's kind appreciation. I am just showing the judgment for a simple how it is in per incurium, how it is not applicable.
So that we can't do it here, sir. No. As a high court, we can't possibly.
Only my endeavor is to show that this judgment should not be relied upon. My endeavor is that since that is the constitutional base of judgment of Priti Srivastava is there, so Priti Srivastava in the ratio of that judgment is applicable. In there, it clearly says that the the medical council regulations are binding.
Yes.
And in case of conflict between the parliamentary law and the state law, as it is made in the Article 254 of the Constitution.
Correct.
So the parliamentary law shall prevail over the state law. And there is a difference between the Jagdish Prasad Sharma judgment and also Dr. Priti Srivastava's judgment is that here also for kind of moment, one line I am showing, sir, how it is per incurium. It is not applicable. It is against the constitutional provisions. It is against the law. I am showing. Your lordship kindly have a glance at page 77. Only paragraph. My endeavor is that this judgment, this Jagdish Prasad is in three parts. Para 77 is totally confusion. It is based on concession. It is based on constitutional federations, and it is based upon the contrary view of the judgment also, that Delhi judgment. I will show how it is judgment. Your lordship kindly have Jagdish Prasad page 662. May I permitted to read? So long as the state legislation didn't encroach upon jurisdiction in the parliament, the state legislation would obviously have primacy over the other law. It is right. But if there was any legislation enacted by the central government under list 3 entry 25, This is important, my lord. Both would have to be treated on a par with each other. It is contradictory to Article 254, my lord. Article 254 says that if in case of the concurrent list, that is entry particularly 25, in case of conflict between the law made by the parliament and law made by the state legislature, it is the parliamentary law that shall prevail over the state law. And the more error blunder has been committed here in this judgment in that next line, my lord. In the absence of any such legislation by the central government under list 3, entry 25, this is, and I'm coming, the regulations, this is very important, vital, sir. Regulations of framed by way of a delegated legislation have to yield to the plenary jurisdiction of the state government under list 3, entry 25. My humble submission is that it cannot be so. Any regulation, any central regulation by means of delegation is a part of parliamentary law, it is a part of a law by parliament. This has been categorically held by in this very long judgment, Your Lordship, kindly organs for only some pages I'm citing. Only one copy, I may excuse.
Yes.
It's a long judgment.
Yeah.
Sorry. Only some part. How it is the my delegation? This judgment says that a delegation, regulations are shall yield to the state act. It can never be so. Your Lordship, only. Lordship, para 322. It is a long. It's only I'm showing it the 7-bench judgment. My Honorable Friends is speaking about 3-bench judgment. I am showing 7-bench judgment. It's and it is describes about. My Your Lordship, kindly have the just into the part. It is validity principles of delegated legislation exhaustively discussed. That has been discussed, and here also CJ, Chief Justice Kanya and others are there. The 7-bench judgments are there. 5 judges are in favor of the judgment, and also 2 with a dissenting judgment. Only I am for purpose. I am showing the paragraph 322, my lord. 322. At page 428. May I permit to read? After quoting the passage from Hodge and versus the Queen, 1884-9 SSC, the learned judge proceeded at page 18. Parliament has not updated its general legislative powers. It has not effaced itself as has been suggested. It has indicated no intention of abandoning control and has made no abandonment of control in fact. The subordinate instrumentality which it has created for exercising the powers remains responsible directly to Parliament for the continuance of its official existence. And the learned judge disposed of the doctrine of agency as follows. The maxim delegators non potest delegare is a rule of the law of agency. It has no reference to an authority to legislate conferred by statute of Parliament. Indeed, the power of delegation being absolutely essential in the circumstances for which the War Measures Act has been designed in Canada, so as to have a workable act, that power of a delegation must be deemed to form part of the powers conferred by Parliament in the Act. The governor in council with the ambit of the Act is not a delegate. The Act constitutes a devolution of the legislative power of the Parliament, and within the prescribed limits, it can legislate as a Parliament itself could. Therefore, it can delegate its powers, whether legislative or administrative. Another para I am showing 382. Thereafter, 382 para. Towards the last portion. 439. Page 439, madam.
Yeah.
Cooperative, I am last line of the previous paragraph. Cooperative Committee on Japanese Canadians versus Attorney General for Canada, 1947 such and such, their lordship said that when an executive authority, that is the governor in council in that case, acts under the authority conferred on him by this kind of legislature, he has no independent status as a lawmaking body. Though his orders are law, they are in reality laws made by parliament at the date of their promulgation. Your lordship kindly have appreciation, my lord. This is even the executive, if it is vested with the power or delegated power, then it cannot be said as the executive power. Their lordship stressed the fact that parliament is the only legislative authority for the dominion as a whole. So this is the view, my lord. And another, your lordship, I'm showing some paragraphs of Dr. Priti Srivastava decision. Priti Srivastava judgment is a constitutional bench judgment of 5 judges. Your lordship, I have annexed that due to the COVID situation, I apprehended that whether I could be able to place that or not. I have annexed the entire judgment. This judgment is, my lord, kindly have a glance at page. Internal page is 78. 78. Yes. Running page is 115. Internal page is 115. This is a constitutional page, and in this case, my lord, towards the last, in this case, the judges of the Supreme Court differ in their views. The majority view is taken by S. Anand CJI, Mrs. Sujata B. Manohar, K. Venkateswamy, and V. N. Khare judge, and the minor views by S. B. Majumdar. The judgments and printed such and such. And you also see whether what is the position, the legal constitutional position, my lord. 115.
It's all right. Read on.
35, my lord. Paragraph 35. This deals with the constitutional position like entry 66 of list 1, entry 25 of list 2, and the position is clearly enunciated and speaks about education. The legislative competence of the parliament and the legislators of the states to make laws under Article 246 is regulated by the 7th schedule to the Constitution. In the 7th schedule, as originally in force, entry 11 of a list 2 gave to the states an exclusive power to the legislature on education, including universities, subject to the provisions of entry 63, 64, 65, and 66 of list 1, and entry 25 of list 3. Entry 11 of a list second was deleted, and entry 25 of list 3 was amended with effect from 3/1/1976 as a result of the Constitution 42nd Amendment Act of 1976. The present entry 25 in the concurrent list is as follows. Here I am emphasizing the point that my learned friend might have been under the impression that since the Jagdish Prasad judgment is about the higher education, and this Dr. Priti Srivastava judgment is about the Medical Council of India, and that may be difference, but there shall not be difference. That is why all are included in the higher education. That is why entry 25 says list 3, education, including technical education, medical education, and university subject to the provisions of the entries 63, 64, 65, and 66 of list 1, vocational and technical training of labor. Entry 25 is subject inter alia to entry 66 of list 1. Entry 60 of a list 1 is as follows. Entry 66 list 1, coordination and determination of standards in institutions or for higher education or research and scientific and technical institutions. Here the gist is as follows. Both the union as well as the states have the power to legislate on education, including the medical education subject inter alia to entry 66 of list 1, which deals with laying down of standards in institutions for higher education or research and scientific and technical institutions, as also coordination of such standards. The state has therefore the right to control education, including the medical education. State has the right to education, including the medical education or technical education. I will show later on, my lord. Even AICT regulations are binding in recent decision APJ Abdul Kalam University and other decisions are there. So my humble submission is that AICT regulations are binding. If the medical council regulations are binding.
Whatever else you put it in a written note.
My lord.
Whatever else you put in a written note. Orders reserved. It will be open to the parties to file the respective notes of submissions within one. All right.
Only one para.
No problem, sir. You put all that in your note. All right. Call it next matter. Right.
I am appearing for some of the petitioners in some of the cases. I need to supplement my friend. I would like to place only one decision. That is in furtherance of the decision as submitted by my friend. That is with regard to that the same thing has been Preeti Srivastava's decision has been well taken into consideration in a very good decision. I have filed the decision copy is already on record in my case. That is 5155 of 19 minutes. Dr. Akshay Kumar Swain's case. But this is a case of Dr. Kalyani Mathavan versus KV Kayaraj and others. That has been decided in 2015. That where everything has been told, and the scheme as a composite, as my friend has submitted, and he is denying, there is no pick and choose policy. The scheme has to be taken in a composite manner.
Right.
Once they are adapting, they have adapted in their rejection order. In my case, I would like to only place only one thing, that document there from their side. That is there in answer 4, my lord. That the word I am placing. The paragraph 4, answer 4 and paragraph 4. The case is examined in detail with the reference to UGC guidelines, Orissa Education Act 1969, Orissa Education Recruitment Conditions so Act 74. Although the petitioners are UGC scale of pay teachers, once they are adopting, they are the UGC scale of pay teachers. Means UGC guideline is a composite one. Once they are paying, the age of superannuation is to be adopted. Once they are paying, UGC paid teachers, they are saying it should be, that should be, that is the age of superannuation should be of that. In that decision copy is very much there with Lord Simans, no file. And one that in contrast, that with if there is a conflict between the state law and the central university, the central law, the parliament shall succeed, and that means this state law should go in that way. Since rule 19 is ultra vires, it should be declared as ultra vires in view of the parliamentary legislation. And here in the concurrent list, both governments, both legislations are competent to make laws, but in case of conflict, that the state law should go. Only the central law should be. I have filed already on record.
May I pardon to mention, my lord? In the meantime, I am appearing for the 11 petitioners. In the meantime, unfortunately, one petitioner has died, so I may be not prosecuted. That is WPC number 30610 of 2020.
Put down that.
30610 of Patitavan Subudhi. In the meantime, he has already
informs the court that the petitioner has expired. The petitioner bids. Let's dispose of the submission.
Obliged, man.
All right.
Supplementary list item number 35.
Item 35.
I'm appearing for the
first matter I'm appearing to in virtual mode, my lord. State has to file counter in that matter.
You have not served the copy in spite of.
On the last date, I had served the copy in the court itself.
No, you have not served.
I can serve again, but I had served actually.
Today morning, I have inquired in the office and there is no.
Court itself, I served the copy, my lord.
My lords, item 35, my lord, it's a PIL and I'm appearing in person. We are talking about that case.
Yes, yes.
The state has filed a counter, my lord.
No, he's got a connected matter.
Oh, sorry, I'm sorry.
If the state is objecting, I have no problem. I will file again a copy. I will serve a copy again to them.
Collect a copy from the soft copy from the government.
I can send it. Well,
soft copy of 26786 of 2020 be collected from the registry by the counsel for the state by producing a pen drive. Reply will positively be filed within 4 weeks, returned up to the next day. We'll have it soon on the opening. 7 July. 7 July.
My lord, this is the second matter, my lords.
I know.
May I please, there are certain issues I'd like to draw your lordship's attention to. They have filed a counter in my case, and I had submitted a note of submission, and they have replied to that also. In that connection, my lords, may I place a
last
point?
occasion, my lord directed the Union of India to file
In that connection, your lordship, may I permit to submit? I'm deeply apologetic, your lordship. The affidavit is ready. Only 3 days time may be kindly granted. I'll file it positively within 3 days.
Counsel for the Union of India, in the second matter, you say Counsel for the Union of India assures the court that the Union of India's counter affidavit will be filed within 3 days. The judge that will be filed for the next. We'll have it on the same day, madam.
Yeah.
7 July.
May I, in the meantime, my lord, something about the state counter I would like to say, draw your lordship's attention.
But we can't pass a piecemeal order, that's why.
Okay. Yeah.
We'll have a full-fledged.
Then let it come after 25th, my lord. If
That's
I
what, sir, after 25th July.
No, April.
7th July.
Oh, my lord. Thank you.
Right.
Supplementary list item 36.
Please, your lordship. This relates to challenge to the Orissa apartment amendment rules as being contrary and repugnant to the provisions of the RERA Act. The counter has been filed. I'm ready for it, my lords. Even the interveners have filed the counter. And no, my lord,
how long will this case take?
I will take only 5 minutes. I just need to place 4 provisions. That will be my case. I'll put my word through.
It will take 3 minutes or 2 minutes?
It's not that simple. For me, it's simple. Even recently, the Honorable Supreme Court has struck down the West Bengal Real Estate Act as being contrary and repugnant to the RERA Act. The entire act has been struck down. I also filed that judgment.
Then you're saying he'll take only 1 minute?
They will take more minutes because they will take much time. I know that.
It's only that it's 3:30. We passed over another important PIL. That's why. Let's finish that and come to this.
Fine.
Supplementary list item 37.
The opposite party has not filed their reply, and they are fill upping the pond, kisam of land, and construction is going on. And also they are alienating the said property by the private OP number 6. Your lordship directed them to file their reply within 2 weeks. They have not filed their reply.
Who's for the state? No copies not served.
No. Sure. 4 extra copy also, sir. That is receipt is there. On your lordship directed on 10.
Not received, it says.
Yes. This is the receipt. This is the receipt. Extra copy. Receipt is there.
Well, I'll obtain another copy from you.
Last opportunity to the government to file its reply within 4 weeks. Rejoined for the next day.
Pardon the mention.
It's on 14 July.
So far, the OP number 5 is concerned. I am appearing for the Southern Municipality Mayor. My name has not been reflected in the first title.
All right.
To that extent,
you put down his name. Okay.
Supplementary item 38. My lord, I may pardon, my lord. Status quo may be maintained because construction is going on, and they are filling the pond.
Well, lots may kindly take it to day after tomorrow. I'll take instruction.
No, earlier there was a direction to file their reply.
But day after tomorrow, lots may kindly give me 1 day, my lord. I'll get the necessary instruction.
Let them file their reply. Status quo may be maintained.
I have no instruction, my lord. I do not know what kind of construction is going on.
Already there is a direction since
there is a big gate. What is this big gate constructed by opposite party number 6 over the passage?
Lord, he is filling the pond and made a construction of 3-storied building. And now she is also alienating the property, said property to other persons because he is a builder.
Who's opposite party number 6? Who's appearing for him?
I am appearing for.
So you'll have to use the mic, sir.
I am appearing for OP number 6, your lordship. In that case,
You can allow the petition because you do not want to file reply, it seems.
No, my lord. Day before yesterday, that was the date fixed for appearance, and also I entered appearance. So 2 weeks time may be given to file my counter, and the fact remains
the order of the collector that is under challenge by my friend, where false assertions have been made in respect of personal property which I have purchased, and pisciculture is developed on that area, and also scientists from Hyderabad and the SIPA, Bhubaneswar, they are coming and they are staying and they are promoting pisciculture. That my friend wants to take advantage of that, which I may not say, for that
Without any document.
illegal.
I have given
No,
the
all
document.
that is the property
You are
that.
making submissions without substantiating
No,
any
that
document. How
that-
can you make such assertion
I
against
am-
the petitioner without documents?
I am submitting to
That
their
is on
lordships.
record. Matter is documents is
Where-
on record.
Mr. Bali, we are also here. You want to ignore us and start talking amongst yourselves?
No, because he's making
No.
allegations.
No,
Allegations.
that you can exchange, sir. If you want us to hear the matter, then you have to respect us.
Yes.
Well, I am submitting to their lordship to file my counter, but you are quarreling.
Hey, you do not have to answer him, sir.
But,
What are you presently doing on the property?
No, that is the physical, the pond as it is. Pond is there.
No, he
Pisciculture
says-
is there. I am not putting even a bucket of mud. Bucket of
No, he says you're going to sell the property.
No, Lord, I am not selling.
All right.
I am not selling.
All right.
I'll make
What is your
counter
name,
after-
sir? Just put down his
Sorry.
name. He appears for opposite party number 6 and states
Sorry,
that
to file
there's no basis for the apprehension that either the pond is being filled up or the property is being sold. He undertakes to file a reply within 2 weeks. It's on 7 July. Right. 14 July. sorry.
Earlier date may be fixed because
It's all right, sir. It's all right.
because he is making let them produce the record, whether it is property has been sold or not. Let them produce the record.
They will.
Tahsildar will produce.
All right. sir.
Supplemental
The
item
short date may be
38.
fixed. Because it will become infectious if they go on doing all these things.
All right.
Item 38.
38 tax appeal. That question is framed running page 10 of the appeal memo.
Yes.
Whether in the fact and circumstance of the case, the learned ITA justify deleting the addition of rupees so made under some 56 ITA Act, the interest of surplus share parked in the bank fixed deposit. This is a case. See, page 3. The amount invested in the FD and mutual funds were not an advance or deposit or earning of the assessee in course of pre-operative business activities. It has been decided in terms of the judgment passed by the Gujarat High Court, and your lordship also considered this in other cases. You also remember that the case of Bokaro Steel, so there is capital pre-operative expense or capital
nature.
Yes, but here slightly different is that the share and mutual funds. There, your lordship decided the fixed deposit, but here here is not a part of the business because it is a mutual funds.
So where is this order of the tribunal corresponding to this?
Yes, that all are paid. All these order challenged before the Supreme Court. From 7867, 78, all is pending. And I have checked out one case, but I am not aware of the other case. 3 cases similar to as today posted, but other cases has not yet been listed.
No, this question which you are raising.
Yes.
Deleting the addition of so and so made under section 56.
Yes.
Where is it dealt with in the?
Yes, they are relied upon the earlier order passed by this tribunal, internal page 4, running page 15. That the DR is on this dispute issued a concern that
the earlier
issues-
AYs 6, 7, and 8, 9.
6, 7, and 8, 9.
What have you done for those AYs?
That may not that we have filed before this court. It has not yet been taken up.
No, it's not listed here today.
No, madam. But I have to check up. One case 7, 8 I have traced out, but 8, 9 I have not traced out. If you lordship keep it one day after, all this matter will be.
Or at the request of counsel for the list on.
I'll give the list by tomorrow.
List on 29th April.
Yes. But so the next item is concerned 39. Is a case addition under section 68. Your Lordship, remember the identity of the person and creditable to the
Correct.
Your Lordship has already admitted these issues, relying on the judgment of the Calcutta High Court. One of the two cases, Your Lordship, has already been admitted. In paragraph paragraph 9 of this judgment.
No, this is the Calcutta High Court judgment.
Yes,
where have
Calcutta
we admitted it?
This is Calcutta High Court judgment.
No, where have we admitted?
Sorry?
No, you say we have already admitted, you said. Where have we admitted?
I'm not exactly basing on this. I'm not exactly remember the idea.
No. Each case will turn on its own facts, sir.
Yes, but here is the similar fact, the creditworthiness and the
No, that is in all section 68 matters the same issue.
Yes. But here Your Lordship see, I'm placing the first assessment order. Your Lordship see the.
No, you see the IT-80 order.
Yes, I'm placing. In the IT-80 order, the finding is running page 33, paragraph 13.
Yes.
We heard the rival submission, peruse the order of the lower authority and material available on record. The appeal under consideration are pursuance of the assessment under section 153 of the Act in pursuance to a search conducted under section 132 of the income tax dated 12/2/13. This is important. The assessment here involve all this appeal is 8/9 for the assessment 8/9 and original return income filed for the assessed tablet agenda. This there are several portion assessment has been made. Then next page 14, paragraph 14. Thus it observes none of the above assessed case assessment proceeding for the assessment 90 was abated in pursuant to the search. In other words, all these cases are unabated assessment in settled position of law that
only on basis of incriminating material. Correct.
Yes. It is settled position law that the case of unabated assessment addition can be made in an assessment made under section 53A of the Act only on the basis of incriminating material found during the course of search. In every position of law, as the judgment has been referred, coming to the fact of the case under appeal, it is observed that all the assessors are duly disclosed the receipt of advance, which is under appeal in their regular bookshop account. The assessors claim to have been sold share against the advance and immediately succeeding assessment 9/10 and also have paid the capital gain tax on the gain derived on sale of such share. It is not in dispute that a related long-term capital gain have been also accepted genuine by the department in the assessment of 9/10. Wherein DR could not point out any material which was honored because of such and which show that the advance in question were not genuine in respect of which addition was made by the assessing officer confirm the CIT appeal. Now you will also see the order of assessment. Let's start from 38. The amount is unexplained cash credit. It is all our advance note. 76030.
But all this is disclosed by them. The individuals have disclosed, they've said how they've sold shares against this. The capital gains has been offered for tax, that has been accepted by the department.
But the assessing,
all that has been ignored.
But the assessing officer is reflected in running page 39. One paragraph not scanning. Also during the post of search, survey under 133A, IT Act was conducted in the business premise of so-and-so to verify genuineness of such credit in your books. During the course of survey proceeding, no bookstore and companies were found, even no employee of the company is available there. Only so-and-so as the employee of the so-and-so company was present in the business premises. Those statements also recorded under the oath, stating him about all possible implications of finding, including treating the company so-and-so as baseless and a paper company. Only in the statement, so-and-so's category stated that only one company, RN International so-and-so, functioning from the said office and no other companies considered running, function from the said office, even for after careful remaining from the premises at third floor, so-and-so, no document relating to so-and-so company were found. The relevant person statement annexed and also the post such proceeding on this content, your relevant person is so-and-so, and that's for page 40. In view of the above finding, the claim of receiving advance or having a transaction with such company apparently not verifiable and therefore no acceptable. Further, on the basis of parameter that is identity of the person from whom such receipt is claimed is
all right.
apparently
No
found
point
to be
just
baseless.
reading the assessment order like this, please. When it has been set aside by the ITAT, you can't
Yes.
simply read the assessment order and say it's wrong.
Because I am placing because DR says there is no incriminating document. Therefore, I am
You have to, if you want this is a second appeal.
Correct.
If you want the ITAT to be interfered with, you have to show us what is wrong with the ITAT's order. You can't show what is wrong by simply reading the assessment order.
No, because DR says there is no incriminating document. Therefore, I am placing the finding of the AO is there. That is.
This is an appeal by the revenue against the order dated 19th April 2018, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket ITAT. In IT. SSA 40/CTK 2018 for the assessment year, bracket A1, 2008-09.
It's still wrongly typed 40. This is 42.
42.
Yes, that's wrongly typed.
No, but what's the name of this respondent?
No,
Ahimsa is correct. It's 40 only.
No, in page 22 is right.
No, 21. Come to page 21. Ahimsa Vinimay is ITA SS 40.
Yes, it's not.
It's correct.
Yes.
For the assessment year 2008-9. The questions ought to be urged by the revenue in the present appeal. Whether the ITAT was right in law and deleting the addition made under section 68 of the Income Tax Act 1961. Paragraph. The perusal of the impugned order of the ITAT reveals that the addition was made on the basis that the amount shown having been received by the SSCs with sale consideration of shares held by the SSC in Mr. Surya Sponge Iron Limited. Were in fact loans. It has been shown to the satisfaction of the ITAT that in the succeeding assessment year, that is AY 2009-10, the shares against which the sale consideration was received by the SSC was transferred to the payers of the amount. So the capital gain earned by the SSC was offered to tax in the return of income filed for the AY 2009-10 paragraph. The revenue was unable to dispute the fact that capital gains offered in the return of income filed by the SSC was assessed to tax in AY 2009-10. The search was conducted on 12/2/2013. But for AY 2009-10 itself, no incriminating material was found during the course of search. Paragraph. The ITAT has correctly concluded that under section 153 capital A of the IT Act, additions could be made only on the basis of incriminating materials found in the course of search. Once it was found that the SSCs had duly disclosed the receipt of advance in the regular books of account and offered the capital gains to tax, which had also been accepted, there is no occasion to make additions on the basis of unexplained credits. Paragraph. In the considered view of the court, there is no substantial question of law that arises for consideration. The appeal is accordingly dismissed.
Supplemental list item 40.
Let's same Lord. So far as item 38, all both the Lords respective both here 13, 14, 15, 16. I will not list this matter 7, 8 and 8, 9. I'll keep the
All
list.
right. So 40 and 41.
Yes, same.
List on which date you said?
29th April.
Or 29th.
Yes. Sir.
All right.
Supplementals for hearing item 42.
May I please, Your Lordship? Your Lordship may be permitted to appear through virtual modules. So this is a case when an advertisement was issued for the post of train assistant driver in the category number 12 on 30/12/1998. In the notification, it was made mandatory that any candidate who is appearing in that has to appear in the written and viva voce test. And after calculating the marks in written and viva voce test, there will be a selection of the candidates. Now, this opposite party appeared in the written test, he qualified, subsequently appeared in the psychological test, he qualified, but when it came to viva voce test, he didn't appear. Even for document verification, he didn't come over before the authorities. Your Lordship, it has been made clear that there has been, he took the plea that, subsequently took the plea that there was a cyclone in Orissa that affected the district and for which he could not know about the advertisement or the date of viva voce test. But Your Lordship, the fact is, in that examination, particularly 910 candidates has been called upon to appear. Out of 910 candidates, 830 candidates has actually appeared. And out of them, the selection has been made. Now, another thing, Your Lordship, it is to brought to Your Lordship's notice that Your Lordship, in this advertisement was given in Dharitri Odia paper on 28/10/1999. That is 20 days after the cyclone. As well, it has been given in the employment news on 13 and 19 November 1999.
That's right. That's all right. All right. You are appearing with the candidate.
Yes, Your Lordship.
What this seems like as a mercy petition before the tribunal. How can it be? Deadlines have to be complied with. If you do not turn up, that's the end of the matter.
Your Lordship, but I could not turn up due to the cyclone, Your Lordship.
Whatever,
The invitation.
there's no exception. You know that. You say the challenge of the present petition is to an order dated 6th December 2004, passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack, disposing of OA number 40 of 2000 filed by the opposite party and directing the Railway Recruitment Board, the petitioners, that is the Railway Recruitment Board, to consider the case of the opposite party for the post of train assistant driver, bracket TAD, notwithstanding the fact that he had failed to turn up for the viva voce test. Paragraph. Interestingly, the reason why the opposite party failed to appear for the viva voce was that he did not receive the call letter and that on account of the super cyclone which hit the state of Orissa in the month of October 1999, he was also unable to produce the documents for verification. Paragraph. The tribunal called for the attendance sheets and was satisfied that out of the 910 candidates called upon to appear before the Railway Recruitment Board, 830 candidates has actually appeared. Consequently, there was no merit in the plea of the opposite party that either that he was not aware of the dates of the viva voce or that because of the cyclone he could not produce documents. What appears to have weighed the CAT is only that the standing counsel for the RRB had submitted that if the applicant had appeared, if the opposite party had appeared with the relevant documents, open quotation, he could have been accepted and offered appointment, as his name was within the list of successful OC candidates for appointment. Paragraph. The second factor that weighed with the CAT was that the opposite party was, open quotation, still without a job, unquote. In the considered view of the court, the above factors were not relevant. Full stop. Thirdly, the CAT went out of the way to ask the Railway Recruitment Board to waive the age restriction after noting that the opposite party was already 29 years of age. Paragraph. In the considered view of the court, the CAT exceeded its jurisdiction in passing the above directions, which seemed to be more out of sympathy for the candidate rather than sticking to the requirements that were to be fulfilled by all candidates who were to qualify for the appointment to the post of TAD. Full stop. And there were as many as 830 candidates who could fulfill all the conditions. And with the CAT being satisfied that there was no justification for the opposite party staying away from appearing the Viva VOC exam or producing documents for verification, there was no occasion for any relaxation of the conditions for the opposite party. Paragraph. The impugned directions cannot be sustained in law. Full stop. The impugned order of the CAT is accordingly set aside. The petition is allowed in the above terms. No order is to cause.
Pass. Supplementary list transfer matter item number 33. Item 33.
Item 33, my lord. Before my learned senior places, my lord, Mr. Lalatru Samantra, who was supposed to handle the case, his younger brother passed away today morning, so he has rushed to his village, my lord. So I'm only praying, my lord, it's an unavoidable situation, my lord. Mr. Lalatru Samantra is
Mr.
AGA.
Samantra, Leonard AGA, who has been appearing for the state in the present case, is in some personal difficulty today. List on. Let me choose a date when. May. Put down.
My lord, in the second sub-item, I have filed an affidavit in court today. It's with the court master, my lord. That may be considered.
Where is that?
The second sub-item in the same matter, my lord. Affidavit. The entire vending zone is being shifted because of SCB medical expansion. That is the affidavit. My lord, I directed to produce some photographs. Because of the vending zone, the entire vending zone is being shifted. Already 10 shops, temporary shops have been shifted. Within the next 2 months, everything else will be shifted out from there.
I may be allowed to give a response to this. I'm sorry to say that always CMC is misleading this honorable court and getting orders. And on that.
Where have they got orders, sir? Where have they got orders? What are you trying to tell us?
Yes, sir.
Where have they got orders?
They are saying that on the basis of the order of this honorable court.
Please be responsible in the submissions you make, sir.
Yes, ma'am. I may be allowed to give a response to the.
There's an affidavit. You just put down this 16602 of 2016. An affidavit has been handed over. Affidavit of the Deputy Commissioner CMC has been handed over in court today. Mr. Chittaranjan Mohanty states that he would like to respond to it by the next date.
16th of May.
16th of May. Supplementary item number 36.
May it please your lordship.
In fact, in the first matter, I'm appearing, my lords. My lord may see paragraph 33 of the writ petition at page 70.
It's going to take time, Mr. Agarwal. Won't get over today.
What I
My
would
lord,
request Mr. Agarwal also is to take instructions regarding this, because actually his clients may not have given him the correct picture. They are all residing there. They have said that the project is incomplete. They are
That is, not
residing in that
the,
place.
that is not the issue here. Issue is we the home buyers are not able to form an
No, but-
association. That is the crux of the matter.
When you are saying in court that the project is not completed on affidavit,
No,
all that I'm saying is let him take correct instructions regarding the factual.
That is
issues.
not an issue here. I'll take care of it. No. Though, because my lord, as your lordship's, by your lordship's last order also, the RERA had asked the IGR, Inspector General of Registration, not to register the flats where association has not been formed, because association is a prerequisite for execution of the sale deed.
That's
but
right.
it is not happening, your lordship.
But the RERA in his affidavit will have stated that it has already directed the IGR for registration of the association.
So IGR is not giving any response, and
In
all this
fact-
illegally it is going on.
Who's for the IGR?
The state represents the IGR.
I'm for the IGR, but the RERA has filed an affidavit today, my lord.
Where is that affidavit?
RERA has been silent on that point completely. Nothing is there on. He has skipped that point. RERA has skipped that point.
No, para 6 is.
That letter was at para 4.29 of my writ petition, but in that affidavit, there is no reply at all to that para, which your lordship had categorically directed last time to both RERA and IGR to take instruction. There is no reply to para 4.29.
No, it says there are some projects which have not been registered, and in those cases, the opposite party is taking appropriate steps to inflict punishment penalty on the erring promoters.
Yes.
My lord, this is not exactly the issue, my lord. Your lordship may then see my letter at annexure 8, page 70, upon which your lordship directed them to take instruction. At page 7070, annexure 8.
This is a reply in Bimalendu Pradhan.
Yes.
In the second writ petition,
That's right.
18799.
Right.
This is the main writ petition, your lordship. All the replies are being filed in this.
Correct.
Page 7070. Section 17 is quote, my lord, this is the heart of the section of the RERA, RERA Act. The promoter shall execute a registered conveyance deed in favor of the allottee, along with the undivided proportionate title in the common area to the association of the allottees or the competent authority as the case may be, and hand over the physical possession of the plot, apartment, or the building as the case may be to the allottees, and the common area to the association of the allottees or the competent authority as the case
So
may
there
be.
is no association of
There is no
allottees, so this is not happening.
No, there is no provision to form the association of allottees, and the impugned rules which have been come up, they say that the association will be formed after sale, which is directly repugnant to this provision.
What are your instructions? You are for the RERA, right?
Yes, ma'am.
Why don't you come to the mic and talk? Have you understood what is being said? This is what you have to answer. How do you solve the conundrum?
My lord, that particular answer is conspicuously absent in my affidavit, my lord.
Then?
I admit, my lord.
Ah.
I also have discussed with the authorities that they must come up with this particular answer.
Correct.
That how the knowledge came to the RERA that this letter has been, which is there in the affidavit, the writ petition. This is the letter.
This is your own affidavit,
Yes.
letter.
Yes. That we have said in that next page that it has come to our notice.
That I have also asked them today that how they learnt about these particular things are happening and this letter was issued. That is, in fact, my lord, I admit that is conspicuously absent in the affidavit. I also
No, and the other problem is the rules. Then how can you say in the rules that association will be formed after sale deeds are over?
My lord,
If you can't register sale deeds without an association being formed.
my lord, may
My
I
lord,
just-
over and above that, Section 8 of the RERA Act says if a project is incomplete, then the first right of refusal will be given to the association to complete the project. So, but the impugned rule says
association will be formed after sale is over.
After completion, after sale deeds have been done, you form the association. So, Section 8 has been completely frustrated and bulldozed in the state of Odisha.
Yes, Mr. Mishra.
My lord, if my lord, I understand the paucity of time today. If my lord gives me 7 to 10 minutes, I will probably be of assistance to your lordship. What is being projected as if the act says that it has to be allottees, but the rules which is being challenged here says post sale. That is absolutely incorrect, my lord. If my lord gives me 7 minutes even today or any time at your lordships, it is absolutely incorrect, my lord. At the face of it, my lord, it is not repugnant. If my lord allows me today, I'll just...
it showed us, right?
My lord, may kindly see the entire case is, it is allottees. My lord, let us start from the definition of allottees itself in the RERA Act. My lord, may kindly have the RERA Act. My lord. Section 2D, my lord.
Yes.
My lord has it, and I quote, allottees in relation to a real estate project means the person to whom a plot, apartment, or building, as the case may be, has been allotted, sold, whether as freehold or leasehold, or otherwise transferred by the promoter, and includes the person who subsequently acquires the said allotment through sale, transfer, or otherwise, but does not include a person to whom such plot, apartment, or building, as the case may be, is given on rent. So, my lord, my first humble submission is that the term allottee being used in the RERA Act is actually inclusive. It's a wider definition which includes wider term being inclusive of even owners. That's my first, my lord, because it clearly says has been allotted, sold. Sold means my lord owner. Now, my lord, now my humble submission is on this premise, my lord, may kindly see section 11.4, which they very heavily rely on, my lord. Now, my lord, if before that, my lord, may kindly see the prayer in this particular. They say that it is, they're challenging the rules, my lord, because they say it is repugnant to section 11.4E, 11.4F, and section 17, my lord. My lord, the prayer is at page, my lord, may kindly have a glance to the prayer as well, at page 24. So this is the three sections, my lord. Now, my lord, may kindly see 11.4E. My lord has it, my lord?
Yes.
Yes. 11.4E says, enable the formation of an association or society or cooperative society, as the case may be, of the allottees or a federation of the same under the laws applicable, provided that in absence of local laws, my lord, may kindly have this, provided in the absence of local laws, the association of allottees by whatever name called shall be formed within a period of 3 months of the majority of allottees having booked. My lord, may kindly say, having booked their plot or apartment or building, as the case may be, in the project. Now, my lord, let me pause here, my lord. Now, my lord, my humble submission here is, my lord, let me, my lord, fairly submit. It starts off saying provided in absence of local law. So first, this act gives precedence that if any local law is there, that has to take precedence. I will also show, my lord, a lot of parametrial law of other states where local laws are present, and our local law is there since 1982. Now, my lord, that is first. So it gives precedence, provided in absence of any local law. Now, second, my lord, I must fairly submit that if there is an absence of local law, then probably here the term allottee would mean, as my learned friend from the other end is saying, allottee means before booking, before ownership.
No, not the definition of allottee also means before ownership.
Yes, my lord. Allottees means ownership and
No. Alternative. It
Yes.
includes a person who simply booked a flat.
Yes, my lord. Absolutely. I bowed down, my lord. But my lord may kindly see now. But here it says provided that in absence of local law.
Right.
Here there is a local law, my lord.
Right.
Now, my lord may
That
kindly
is what
see.
is being challenged here.
Yes, my lord. But now, my lord, they are saying that the local law is in repugnancy.
Yes.
But the fact is, it says provided in absence. If there is already a local law,
Yes.
then they don't have to follow whatever has been provided in the proviso, my lord. That's my humble submission. Now, my lord, may kindly see section 17. If their reasoning is given effect to, it may lead to absurdity, is what my humble submission is. My lord, may kindly see section 17. What does it say? Transfer of title. Now, my lord, may I read it? The promoter shall execute a registered conveyance deed in favor of the allottee, along with the undivided proportionate right in the common areas, to the association of allottees or the competent authority as the case may be, and hand over physical possession of the plot, apartment or building as the case may be, to the allottees and the common areas, to the association of allottees or the competent authority as the case may be in a real estate
This
project.
has to happen simultaneous. So the day you execute the conveyance, the conveyance itself will say this is going to you as the individual allottee, this is going to your association.
Along with.
Exactly, my lord.
So unless there is an association, you can't have a conveyance deed.
My lord, my humble submission is,
which is what he's arguing.
No, my lord, let me say what my friend is arguing. Let's say, my lord, a project is launched today. My lord, may kindly envisage this.
Let's say the apartment has 50 flats. All right. 42 or even 45 have booked their apartments. Right? Since a majority has booked, forming an association is mandatory now.
My lord, if at all they say so. No, my lord, because my first submission is, my lord, my first submission is 11.4e says provide in absence of local law. There are a lot of local laws similar.
We talk of Orissa. Forget about
Yes, my lord.
any other state.
Yes,
in
my lord.
Odisha, there is one local law now.
Yes, my lord.
That local law unfortunately says till the sales are complete, you can't form an association.
I bow down.
Then how can that be sustained? It really runs completely contrary to this proviso to 11.4.
No, my lord, my humble submission
11.4 says 3 months. It is only for the months, for the period.
3 months.
For the period only if there is no local law. Suppose for after booking, there is no local law saying within how many months of the booking you have to form a flat, then it is 3 months. Suppose Odisha law would have said that after 6 months of majority of booking, you form an association, that would have prevailed. But if Odisha law would have said, would not have laid down any period within which association would have been formed, then yes, 3 months. But it is completely contrary. It is going after sale.
My lord, may kindly envisage this. If section 17 says only allottees and not owners, my lord, may kindly see, because allottees would include owners and allottees.
Yes.
Allottee definition, my lord, includes allottees and owners.
Correct.
Now, my lord, may kindly envisage this. If 17 will be read as only allottees and not owners, that means a day.
Why should it be read like that? I don't understand. See, there will be owners which form part of the definition of allottees if after being allotted, somebody sells his flat.
No, my lord, allotment is at booking when somebody's books at 10%.
That's right. I'm saying what the owners will come later. At the stage of allotment, we only have an allottee.
I bought on. Now, my lord, here if on the section 17, if my learned friend's definition is accepted, now at the moment when somebody is booking with 10% and the project is not even completed or half built, then they are asking that the common areas which have not yet been made should be transferred.
I'm sorry. Nobody will go for execution of a deed of conveyance till the completion certificate is done, the building is up.
Occupancy
all those occupancy certificate, those conditions have to be satisfied. Nobody is going to execute a conveyance, please.
Well, that is precisely what section 17
the conveyance deed will identify the flat as such. If there's no built flat, what will be conveyed? Nothing. There's no question of a one part conveyance deed for the common area. There will be no common area also unless all the flats are there. So that contingency does not arise that an incomplete building will somehow be conveyed. That is not the question.
But my lord, that is precisely what my learned friend is saying.
No. He's talking of forming an association. The forming of an association does not require a building to be there. That's what he's saying.
No, my lord. I bow down, my lord. My lord, my submission is he's showing the letter that was just shown to your lordship. The letter which was just shown to your lordship has quoted section 17.
Correct.
And on the basis of section 17, they are saying that you form an association because section 17 asks you to form an association.
Not section 17. The proviso to 11.4 asks you to form an association.
Yes, my lord. But that is only in absence of local law. My humble submission is, my lord. My lord, may kindly.
No, in the absence of local law. So if there is a local law, you form under the local law. If there's no local law, you anyway form an association.
Yes, my lord. The local law says that it is to be done after sale, which is the owners.
Which is absurd. Because the local law can't postpone the formation of the association contrary to the RERA Act.
My lord, may kindly see 11th 4F. My lord, may kindly see the next proviso. Execute a registered conveyance deed of the apartment, same conveyance deed of the apartment, plot or building as the case may be, in favor of the allottee.
This is exactly 17.1. This is a repetition of 17.1, please. This is a repetition of 17.1.
My lord,
so in fact, even the promoter will require the association to be there. Only then he can execute this conveyance deed.
No, my lord, that is precise. I bow down, my lord. I bow down, my lord. That is precisely what is being done. My lord, may kindly have a proviso to section 17. My lord, kindly have a glance to proviso of section 17.
Yes.
My lord, may kindly see. Again, proviso says, provided that in absence of any local law, conveyance deed in favor of the allottee
it's actually perfectly in sync with the other provisions.
My lord,
if there's a local law, you do it under the local law. If there's no local law, do it within 3 months anyway.
Yes, my lord. My lord, may kindly see 3 months of getting the occupancy.
Correct.
My lord, may kindly see. So, my lord, by occupancy, my lord, may kindly have a glance or kindly have a my lord, maybe may I kindly try and ensure, my lord, the occupancy certificate is got after the project is complete.
Correct.
Now you get an occupancy certificate.
Correct.
And the RERA also says that the sale deeds for the buyers has to be executed within 3 months of occupancy. Now, my lord,
the association formation doesn't have to wait till the occupancy certificate is given, I say.
No, my lord,
the association can start much earlier.
Majority of
3 months of the allottees having booked their plot.
No, my lord, that is my lord, the entire thing starts with whether it's a local law. And local law says it is in owners.
Local law is therefore being challenged, please. I think you're missing the point. Local law is inconsistent and contrary to this act.
Lord,
clearly contrary. There's no question at all.
My lord, my humble submission.
Local law makes this act unworkable. And how can you allow a local law to make the central act unworkable?
My lord, my humble submission is, this, my lord. Now, my lord, if 11.4e is given effect to, as in to say that the association of allottee be formed. My lord, may I just envisage this, my lord. If an association of allottee is formed,
but I don't understand. You're the promoter, right?
My lord, we are a group.
Why should we should be joining him? You should be saying, listen, even my hands are tied. I'm unable to execute any conveyance deed. My building is ready, but association is not formed, and therefore I'm not able to execute conveyance deed.
My lord, that is precisely what I'm saying. The local law says that you form an association as soon as you sell.
How can you?
No, my lord, because
this act says it should have been formed much earlier. Please.
My lord, the Apartment Owners Act came into force in the year 1982. My lord. So therefore, at that point of time, the modalities or the words used in the RERA Act, that occupancy certificate or my lord, any such specific words which were there in the RERA Act, that was not there.
Correct.
And the rule.
And how will you transfer common areas to an association? On what basis will you transfer?
We do an association. My lord,
no. So unless you've sold, you can't form an association. Under the conveyance deed, you're supposed to sell to the association.
We do it, my lord. My lord.
No.
Now, my lord, may I only see?
You'll have to say a hypothetical association which is hereafter going to be formed.
No.
In the conveyance deed, you have to write, right? You have to give the name of the association. In the conveyance deed, you will say this is flat 5A. This is the common area. You say 5A goes to Mr. X, common area goes to association. There is no association.
There is an association. My lord, that's what I'm.
How is there an association?
To answer all your lordship's queries, section 8. Let them say how section 8 will be complete. I'll take your lordship to section 8. That will give a clear picture, your lordship. Obligation of the authority consequent upon lapse of or on revocation of registration. I'll read it, your lordship. Upon lapse of registration or on revocation of registration under the Act, the authority may consult the appropriate government to take such action as it deemed fit, including carrying out of the
First right of refusal.
First right of refusal is to the association.
Second proviso.
So after sale, you build the association. Then suppose if a builder, he doesn't construct the flat since 10 years. So that means there is no association. I cannot have the first right of refusal. This is where the promoters are aggrieved. The project will go out of their hands to the association. First right will go to the association. This is the point, last point I would like to make. This is
I'm surprised that the promoters are not joining the allottees.
No, my lords, I'll just explain, my lords, why this problem has come. Now, this act has come in 2016. After that, actually, the builders and the promoters, they are not all saints. I must say that. But then what we are facing here, in fact, if my lord takes up the first case, that's why I pointed out whether my learned friend would take instructions. We have been taken to the economic offences wing. We have been taken to the consumer court. We have been taken to RERA. And also criminal cases here, anticipatory bail applications are objected and court commissions are appointed to look whether the project is in order or not. So this is the first case that we are dealing with. In the first matter, this is the fate of the builder. So as it fell from your lordship, it's correct that we should actually join hands and try to improve the scene. But we are at the initial stages. This is what we are facing now.
No, but we are on a very small point here.
My lords.
How do we ensure that an association of allottees is formed? That seems to be one of the starting points.
My lords.
Once 80% of allotments in an apartment is booked,
my lords,
you have to have an association.
Right.
How do you, that's the starting point. That does not wait for the occupancy certificate because conveyance deed awaits occupancy certificate.
My lords.
That's what he pointed out, which is correct. So the sequence is booking of allotments. The minute it crosses the majority, form the association.
My lords.
Whether it's one basement is there or even foundation stone also, foundation is also not laid, it's not a problem. Once the booking is there and whatever booking amount has been given, and you have identified allottees, and if they form the majority of the total plots available for sale, flats, you have to form the association. If there's a local law, form it under the local law. If there's no local law, form the association anyway.
Here, I think
you probably form under the Societies Registration Act or something.
Yes, in fact, that's precisely our point. That association under the Societies Registration Act is not barred by any of the laws.
That's the whole problem. Now you come to the rules which have been challenged. This is the whole problem, the apartment owners' rules.
Now the problem here is that local law is actually not the rules. It's the 1982 Act.
No, and the rules are under that Act.
Yes. So the Act has not been challenged.
No. He does not have to challenge the Act. There is no provision in the Act which is running contrary to this.
Yes.
It is the rules which is saying if you want to form an association, first you have to be an owner. Now, which is the chicken and egg conundrum then we put in place.
Correct, my lords. Now, our point, the point that we are trying to make is that if my lord takes up the definition of allottee in 2(1) of the RERA Act,
we just read
then that includes owner.
Yes, but it includes a person who's just booked a flat.
It also includes an allottee.
So for the purposes of the proviso to 11(4),
my lords,
you're only looking at allottees because they're not owners at that stage.
My lords.
So you have to give effect to every provision. Nothing is redundant.
So now what has happened in other states, they are all having these ownership associations. None of them have, in fact, if it actually happens.
So let us get RERA to answer this.
My lords.
See, they should join everybody in saying, get rid of this rule.
My lord.
Now,
you must say, get rid of this rule if you want the Act to be implemented.
My lord,
why should people who've spent precious money, even the builders have spent precious money.
Yes.
The builders have all borrowed from banks.
Yes.
So they are running into losses, the interest mounting. Apartment owners are not getting conveyance deeds. Their precious money is all locked up. The savings are all locked up. So how does it help anyone? This kind of a rule which prevents association being formed and therefore prevents conveyance deeds being registered.
So, my lord, what falls from your lordship is correct, my lord. In fact, in this case, we have been taken to the Lok Ayukt also for a building violation. So then why have the RERA at
My
all?
lord, they have sold us the flats in 2017. Let my learned senior answer when did they get the occupancy certificate?
So that's for RERA to look
They
into.
got in the year 2021.
But anyway, that's not the
That is not the
subject matter
point here.
So the trust
should not be
deficit, my
raised.
lord,
You say-
lies there.
Okay, you say in 18799 of 2021, the Orissa Real Estate Regulatory Authority has filed an affidavit, which has been handed over in court today by Mr. Niranjan Swine, Senate counsel appearing on its behalf. However, the court finds that RERA has not given a reply to para 4.29
of my writ petition.
of the writ petition, which specifically makes a reference to a letter written by RERA to the Inspector General of Registrations on 14th May 2019, drawing attention to section 17(1) of the Real Estate Regulation and Development Act 2016 RERA Act, and specifically stating that requests for registration of conveyance deeds in respect of real estate projects should be rejected if ownership of the common areas is not conveyed to the association of allottees as is required under the said provision. Paragraph. In fact, RERA should make clear its stand on the main prayer in the present petition, which is for declaring the Orissa Apartment Ownership Amendment Rules 2021, which mandates that an association of apartment owners will be formed only after execution of conveyance deeds.
8 conveyance deeds.
8 conveyance deeds in an apartment, as repugnant to section 11(4)(e), 11(4)(f), and section 17 of the RERA Act. The additional affidavit of RERA making explicit its stand on the above issue will be filed positively before 25th April 2022. Is there an interim order? No, I don't think there is an interim order.
Well, only IGR should also respond because he is the executing one.
Mr. Das, appearing for the Inspector General of Registrations, states that the IGR states that the IGR's affidavit will also be filed by the same date. List on. Right now, we'll put it for 12th May. Let's see.
Your Lordship has heard it finally.
And there's one issue which since we are looking at
it cannot be undone because these sales which are happening, it cannot be undone. That is the whole problem.
What sales are under the once the ownership is transferred, sales are happening.
No, but how are they happening? What are you saying? Show me a sale deed. What does it say about the common areas?
Common areas are transferred to the owners association, which is in terms of the.
There is no owners association.
No. Owners associations are formed. Owners after completion. Let me clarify, my lords. It's not that we are. In fact, we want a positive this sector to grow in our state. So after ownership is transferred, these are transferred.
No. It's see in that clause, in the conveyance deed, you'll have to say, I'm transferring the common area to this owners association.
Yes.
Which doesn't exist.
No, that is formed. Now we are at the stage.
So it is an owners association which is hereafter going to be formed after the date of the conveyance deed.
My lords, I'll explain that. That means now we are looking at what stage the common areas would be transferred. Whether it's at the stage when the project is ongoing or when it's completed.
After the occupancy certificate is given,
my lords,
within 3 months thereafter, you'll have a conveyance deed. There'll be only one conveyance deed, please.
My lords,
not in piecemeal.
It is in favor of the owners association which is formed.
Which is going to be formed. You are missing that essential point, please. There is no owners association at that stage.
No, after getting the occupancy certificate, within 3 months, the owners association is formed and thereafter this transfer happens.
How can it be? There is no owner unless you have a conveyance deed. You're
No,
talking.
ownership.
You're getting into a trap. Just think about it. There is no owner till there is a conveyance deed.
Now, my lords may kindly see the problem would be that if we transfer common areas to the allottees.
No, the only solution is we should have an association right in the beginning, please. Even much before the occupancy certificate, you should have an owner allottees or association.
Now, my lord may visualize this. Of course, today we are short of time, but there is one small point here. Now, there may be a section of allottees who may not live the entire project. They may
they'll get substituted by whoever is paying the allottee. So, say I just sell my allotment. Okay, the building is only 20% complete.
My lord,
I sell my allotment to another person. He steps into the shoe of the allottee.
Now there may be
a member of that association.
What we are doing, my lords, is that after the project is completed, after we get the occupancy certificate, a ownership association is formed in terms of the rules, and then the transfer happens.
Just imagine. I'm just saying you can't use these terms loosely, right?
My lords.
If we start using them legally,
my lords,
then we are running into trouble. We cannot have an owners association after occupancy certificate without a conveyance deed. Correct? How can you have an owner? How do you call a person owner who does not even have a conveyance deed in his favor?
So conveyance deed, there are two conveyance deeds which are visualized. One is for the independent flat.
No, there'll be only one conveyance deed, sir.
No, conveyance deed for
conveyance deed. No, there can't be two.
Malas, may I explain that? Now, for independent flats, there would be a conveyance deed for the individual owner, and there would be a conveyance deed for the owners association. For the common areas.
Then you've not understood, because from whatever happens in all the other states, I can confidently state there are no two conveyance deeds. In that one conveyance deed, you will say this is what goes to the allottee, which is a flat identified the space, and the common area is the ownership is to the association.
We all take loans on the basis of that sale deed or the mortgage property. So individual owners do get a sale deed, which is hypothecated with the bank.
No, that's right. Every individual owner will get the sale deed. That sale deed will mention the share in that common area, but that common area is transferred.
Yes, here also it's transferred. No builder, now post there no builder latches on to that common area. Now, as it fell from your lordship, the question is when the association should be formed. Whether it should be at the initial stages or after completion of the project.
No, the Act doesn't give you a choice on that. The Act says within 3 months of the majority booking completed, you have to form the association.
Now, the problems that we are facing, my lords, is handing over the common areas in a multi-phase project. There probably you would run into trouble with the association. That's
the main problem you have is in many of these instances, you don't have the association in place. That's the biggest problem you're facing.
That in fact needs to improve. For that, we have RERA as a monitoring body.
No, this rule has to go. Then you stick to the Societies Registration Act. It makes it much simpler then.
In fact, the state has admitted this rule is contrary to RERA. The Act is contrary to RERA Act, and they are already drafted a new legislation which has been vetted by the law department. They have themselves stated it. But why then this has been brought as an interim measure, they are saying. When the Act is contrary to the RERA Act, they are themselves stated.
This rule has been framed under Apartment Owners Act. So your lordship, I think only point, what my learned senior was also saying, Lord. Now, if your lordship will see the definition of apartment and definition of apartment owners and other definitions envisaged under the Apartment Ownership Act and the definition under RERA Act, these are all.
Once RERA Act is there, it covers the entire field, please now.
But this rule has come only to provide the.
No. If this is contrary to that, it will have to give way to the.
Therefore, in our counter, we have stated that we do not have any separate rule as of now to register.
No, but this rule is coming in the way of the association being formed.
But associations as on date are formed under the Ownership Act and it's transferred. The common areas are transferred in the prestigious projects. But then we always
on the next date you give me samples of the sale deeds.
I have given.
We would also give our sample sale deeds so that the court can look into.
All right.